function activity. Lord, may I leave to mention for inclusion application, my lord.
New application.
And new application.
May have my lord review application.
Sorry.
My lord,
Review of which order?
Right.
Our order.
My lord. Like this. Get to
New application.
Yes.
my lord, may I permit to mention for inclusion new application, my lord.
Yes.
Grateful, my lord.
As a similar prayer, my lord.
May I permit to mention, my lord? There are in appeal, my lord, we file. Matter is already decided where the respondent make the win the interdistrict ferryghat e-auction, and thereafter make the process and complete the 50% of payment, near about 50% payment of the e-auction amount, and afterward a writ petition filed, and there is a order passed in favor of the petitioner, my lord. But yes, my lord.
What do you want?
My lord, I want kindly grant me leave and without certified copy, my lord.
What is
We
it?
applied for certified copy, my lord.
When did you apply? When was the order passed?
My lord,
You check up and mention. Yes.
my lord, new application.
Yes.
My lord, with your lordship's kind leave, I wish to mention two
Second.
matters: an application for stay.
New application. Or it is of which year?
Yes, ma'am. Yes, my lord. New application for stay.
It was never heard earlier.
It was heard, but it was dismissed, my lord.
Dismissed.
The considered honorable dismissed the writ. Yes, my lord.
Has the new application that you're mentioning been heard previously?
Not in this court, my lord. In considered honorable my lord, it was heard in another court, but it was dismissed. Both.
Then have you given notice to your other side?
Yes, my lord.
Where is the notice?
Notice. My senior is not present, my lord.
You give a notice to the other side and mention on Thursday.
Okay.
Yes.
Kind leave to file an appeal without certified copy.
What
But
is
the
the
order passed
urgency?
on 6th
Uh-huh.
August.
Huh?
Already we have applied for certified copy.
When was the order passed?
Pardon, my lord.
When was the order passed?
Order passed on 6th August this month.
What is the urgency,
So,
sir?
urgency, my lord, the school authority conducted interview to the post of assistant headmaster. Subsequent panel was forwarded before the DI for approval. DI sitting time more than prolonged. Thereafter, all on a sudden, DI issue notice to cancel the without assigning any reason to conduct the re-interview. Then we have filed a writ application challenging that notice. The learned single judge quashed the notice. Subsequent directed to school authority to conduct the re-interview.
Re-interview.
Yes,
You are aggrieved by that?
yes, my lord.
Leave granted. Yes.
My lord, for the impugned order, my lord, the respondent in this matter not able to use the ferryghat, and why the petitioner win the bid, my lord, and make the payment.
What do you want, sir?
Yes, my lord. 2nd August is.
What do you want?
My lord, kindly grant me leave and or without certified copy. We applied for certified copy.
Without the certified
Yes,
copy.
my lord.
When was the order passed?
In the favor of the petitioner, my lord.
When?
2nd August, my lord.
And when did you apply for the certified copy? When did you apply for the certified copy?
On that day, my lord. 2nd August, my lord. We applied for the certified copy on 2nd August.
Show us your
That is the
application.
order.
Show us your application for certified copy.
We applied for
Application, my lord, not carried. Right now, I'm not having the.
Group 9. Tea auction. It's about a tea auction.
Yes, my lord.
We don't have determination to take it up. It's a group 9 matter. Check it up and mention. Yes, call the list.
Grateful, my lord.
Appellant.
Yes. Broken or sprained? My lord. Broken or sprained?
Sprained.
होगा भैया
In item number 15, I am for the writ petitioner, respondent.
In item number 1, I am for the respondent with petitioner.
So it was extensively heard by Justice Sen. Then why it has been released?
Well,
You couldn't
earlier-
say that.
Well, earlier what has happened in the matter?
When the matter was fixed before Justice Sen,
Hmm.
the Honorable Justice Sen, my lord, by this time determination changed.
But it was extensively heard by that.
That was mentioned because want of determination, my lord, could not, my lord, hear this matter.
You
and
could
that
have,
is why-
you could have made an application for
My lord,
assignment.
we have did that, but they were sitting tight over the matter. We are verbally told we cannot, since the court is available, my lord, the determination is available. That is why unless your lordship, my lord, two ways, my lord, either your lordship, my lord, kindly hear, and I'm led by Mr.
নিজে record করছে।
In this matter, my lord, what has happened?
এটাই তো হয়, ওরা কোঅপারেট করছে না।
এই, আমি সই করে, এই, তুমি
সই করে দিলে এখন
বাবা-
নিয়ম নয়, you have to apply also. মানে the old process, মানে procedure has not been adopted by the Secretariat of the Honorable Chief Justice. Earlier used to be, if we apply for, they have to endorse it. Now this Chief Justice Secretary says procedure is everybody has to apply, or the Honorable Court, the regular bench has to release it. Now, my lord, I tell you, lordship, proprietary demands, this should be heard by the same bench because we have extensively argued.
Recorded in the order.
Then written note submissions, then only your lordship, the last clarification needed by the last order. That's the only thing. Or your lordships can take it up, but it will take little time
And
and
a
give
report-
me 3 or 4 days second half.
And a report.
Because
is
it's
required to
heard
be
on
filed
7
by
to
the
8
board.
days.
Kindly see that. And a report is required to be filed by the board. There is
That's-
a direction for filing the report.
That's before this, that particular honorable
No,
bench.
if it has been heard by their lordships,
Yes, yes.
and for he's right, because when we were at the bar, we used to request our other side that do you agree for assignment as it was heard.
They filed
The
an
advocate-
application for assignment before the
But you have to endorse it, na? That
They
it
have
was not
endorsed, my lord, they have endorsed.
endorsed.
Chief Justice Secretary said procedure is now different. Everybody has to apply or the regular bench has to release it. That's why we have mentioned it. They have not applied. Procedure has been little
That is
changed.
not procedure. They applied for the assignment.
Then we are releasing, we are recording this and we are releasing.
That would be better, your lordship, straight away.
I don't have the
খেলতে চাইলে পরিষ্কার বলো, I don't have anything, I will play.
আরে তুমি
না, ছেড়ে কাজছো না ভাই।
সেই খেলার মাঠের কথা শুরু করে দাও।
Mr. Shanna Lanet, senior advocate appearing for the appellants.
one thing subject to lawsuit sanction, which has been heard extensively by the honorable bench, just presided by Justice Sen, let it be heard by that bench. Your lawsuit for the other appeals kindly keep it side. Let the judgment be passed, then your lawsuit is considered. That would be proper.
Your lordship already
Yeah.
decide the issue in another matter.
বাধা
And
দিচ্ছে।
to Supreme Court, it is settled. The issue in Shumanto.
Raise that before the other bench.
I have
That's
been-
been
item number
extensively
40.
heard, notes of argument filed. You see the amount of time, energy and expenditure that.
No, one day, whole day,
না 3 দিন argument
and then second half 3-4 days. Mr. Bhattacharya argued it. It was adjourned several times on the ground of Mr. Bhattacharya, since he was not available
They
in
also-
Parliament.
they also took
That's
time.
I'm not saying that I have never taken
Question of
time.
taking time. It's a question of matter being
I'm in the
heard.
habit of taking time. I admit it.
So will we record that you are aware these written notes of arguments were also filed?
On our part, written notes had not been filed. On our part, because
Have they filed it?
viral file করে দিল both sides
I tell you, lawsuits, I have said
written binding with the all records.
all records, spiral binding, both sides directed, and that's really our argument.
Notes of argument.
Mr. Sharma,
written
you
notes of
tell us a
argument
date,
file এ
we
আছে
fix it on
That's
that.
After vacation, dear lawsuits, what should we do?
After vacation,
that's
we have urgency, urgency is that
There is
we are 2020 DLED batch candidates. What has happened? We have a degree of elementary education as well as BA. Now, the primary board at the time of interview in terms of the order of the Honorable Supreme Court, they are not allowed us to participate in the recruitment process.
Have you filed any injunction application? Have you went up in contempt?
Yes, they have went on
They have
contempt.
contempt.
To take steps there.
হ্যাঁ তাহলে তো আমরা
No, then I will be in a soup, my lord, again. Because otherwise there is no stay. It was hard.
প্রতিষ্ঠান
at length.
শুনেছিল তারপরে চলে যাওয়ার
For
পরে
you ascertain, you sit with your fellow colleagues who are in the other appeals also.
They are also appealing.
Already, yes, quite 15 years.
What do you say, Mr. Jana?
I mean, item number 11, my lord, I paying for before your lordship, let it be heard by the, just, honorable just saying. My lord, let
Then
it be
you are
released,
in which matter?
let it be released. my lord,
Who
we-
is on item number 1?
I am on the item number 1.
Yes, what do you have to say?
But if my lord decided,
No,
I
my lord, we are asking you a question. We want a definitive answer from you.
my lord, we are to the matter in this court.
Boyota.
Then fix it up, your lawsuits, any day convenient to lawsuits.
Mr. Sharnal and senior advocate appearing for the কত আইটেম নাম্বার?
16th তো এটা ওদের
ও মডিফিকেশন
modification.
নট দিস উইক করে রাখো, নেক্সট টিউসডে দিয়ে দিও, এই টিউসডে পরের টিউসডে দিও। মডিফিকেশন অ্যাপ্লিকেশন মেনশন, ইয়েস নেক্সট আমি একটু দেখি।
My lord, I appear for that.
Yes, what is the matter?
My lord, matter relates to transfer on distance ground. Transfer on distance ground. My lord,
You take your seat, take your seat. There is a section 5.
section 5 ছিল? Yes, my lord. কতদিনে delay? 26 days delay. কত?
Yes, tell us what is the wrong in this order?
My lord, transfer a teacher, my lord, having been approved and continuous service for 5 years may apply.
That is in the general transfer
General
rules. So that is applicable to primary also.
Yes, yes, primary rules, my lord, says so. My lord, that in terms of that circular, my lord, rule, I made an application. That has to be decided by the authority. My lord, there are certain criteria to be, my lord, considered at the time of deciding my transfer application. My lord, learned trial judge here dismiss my application.
Show us what is the procedure to be followed
Lord,
once an application is made.
sir, 2002 এর 19 এরটা কথা। এই দেখো, 2002 এর রুলটা আছে তোমার কাছে? বইটা আনোনি কেন? 2002 এর বইটা যেতে রুলটা অ্যানেক্স করে। দুটো কপি দিয়েছো তো, না একটা কপি দিয়েছো? দুটো কপি দিন, আর একটা কপি দিন, দুটো কপি।
Yes, Mr.
Rule, this was substituted, my lord, last column, rule 2.
Last column of which one?
Well, first page, rule 2. For clause B of rule 4, substitute the following clause. On application from a teacher, transfer approved teacher within its jurisdiction from one primary school to another primary school on the condition that such approved teacher, in case of mutual transfer, is confirmed, and in case of single transfer, is confirmed and has completed minimum 5 years of continuous service.
Where is the parent rule?
And parent 2002 এর রুলটা তোমার কাছে আছে? ওই অনন্যা মামলা করতেছ না, আগের দিন বইটা এনেছিলাম।
On an application from a teacher,
Yes.
transferred approved teacher means
Approval of service, মানে 2 years completion of service, মানে a teacher is approved after completion of 2 years service.
oh acha.
Initial appointment is probation, my lord. Then after completion of satisfactory 2 years service, approved.
So 5 years will be from date of approval,
Not from the,
from the date of approval.
Joining. Date of joining.
Acha, within its jurisdiction. And on the condition that in case of mutual transfer is confirmed, and the single transfer is confirmed and has completed 5 years.
Both I have come, my lord.
Very
Full.
good. Then
Thereafter, the authority shall
now
decide.
this has been uploaded in the portal.
No,
This is not through
no,
portal.
no.
That Uchshasri is
That
for
is suspended.
secondary.
my lord, right now, my lord, for the primary, my lord, mutual transfer through Utsotsri portal.
Oh,
That's
Suspend for right now in the primary for mutual transfer only.
so then what happened? Who then what is the procedure to be followed?
My lord. Next page, 3A.
Yes. Online or through a designated portal for transfer. To the
While
concerned
considering the transfer application made under Rule 3, council shall examine the following. This has to be examined and thereafter they will take a decision. Either
the sub inspector will forward it
Right.
to the council. Now, where is the next rule? Council's decision. Now,
Here-
3A.
my lord. Lord, next page, Rule 5. Inter-council transfer. This is my case. Because
You're from one district to another
Another.
district. Rule 5.
yes. My lord, Rule 8, that is 5, here 5.
Inter-council.
Yes. While considering inter-council transfer in accordance with the provisions of clause K of section 19(1) of the Act, the board shall mutatis mutandis follows the provisions of these rules, particularly sub rule 3 of rule 5 of these rules. Therefore, board will consider.
So, when was your application made?
My lord.
Have you annexed?
Yes, yes. Application made on 27th September 2024, page 31 of my stay application.
Yes. Then there was no reply.
No,
So
it has to be decided by the board. Only this.
So before that, court said that
Your ground is not justified.
Consider করেন consider আগে বলে কি চাইলো দেখি
যেহেতু কোর্ট এখন নিজে বুঝে গেল আমাদের হচ্ছে না কোর্ট নিজে
Section 5.
Ashok, the present appeal has been referred.
Delay has
Who is your other side?
Other side
Have
is
you
the,
served the application?
yes, Lordship, I have served the copies. This is my affidavit service, Lordship.
Chalo, day after tomorrow করে দিও ওটা।
Grateful, Lordship.
You show us the provision how after disposal of the appeal,
Yes,
we
Lordship.
can say that you substitute this person. Then we have disposed of an abated appeal.
Lordship, that
For non-mentioning this fact, we have disposed of an abated appeal. So our entire judgment goes. There must be a limit of carelessness on the part of the persons. You got a favorable order. Now they will come and fight that you cannot add a single line. It is an abated, an order passed in an abated appeal. Go.
I'm praying apology.
Serve upon your other side and come and study. Show us the provision and judgments. Come with that. Only I have an application will not allow you. Our entire effort has gone. Yes, next. And who appeared? Who was the senior? Mr. Nilanjan Bhattacharya appeared, na?
Yes, Lord.
Nilanjan appeared?
Yes.
Huh? You were not there. Are you the advocate on record, sir?
No, Lordship.
Then who is the advocate on record?
Mr. Ravi Ranjan Kumar.
Where is he?
He is engaged in court number
Oh, wow.
36,
Where
Lordship.
to that? Huh?
Are you there in the matter?
Are you there in the matter?
No, Lordship.
তাহলে ওই next Tuesday যেরকম
No, Lordship. I will serve.
this conduct is not proper. Ask your senior to come. It is next Tuesday if we alter it. ওই যেরকম আছে সেরকম রেখে রাখো। Yes, yes, Mr. Bhattacharya, why you are coming with such a big brief? কত কি add করেছে? আগে delay. How many days delay?
220 days.
But I will file Malad affidavit. Malad section 5.
This delay issue is caused because a judgment was passed by this honorable court on 1st of March 2017 on the issue as to whether
You take your seat.
B.Ed with special education can be treated to be a training qualification for awarding 15 marks for a candidate having that qualification.
Which selection process?
Primary 2016 primary school primary selection.
Oh,
Recruitment
yes,
of
that equivalence is the issue.
not the equivalence.
Then
That qualification training, whether it should be treated to be a training qualification or not, special education.
so you are not getting a category.
Ultimately I succeeded in the writ petition.
Very good.
Writ petition, it was held that
Let's
yes,
see.
they should be granted the status of a trained candidate with the qualification of special B.Ed with special education. 1st of March 2017, that judgment concluded, no appeal. We were appointed, the petitioners before your lordships were appointed, since we had that qualification, after the judgment passed by the honorable court.
Under trained category or
Under trained category. Because untrained malad we did not qualify. After the training marks was added to me, malad, I became qualified. And malad, accordingly, we were appointed after the judgment passed by the honorable court, sitting singly. And we have been given appointment as trained A category scale. We had no grievance.
then what is the problem now?
In 2022, on the basis of the judgment of my order of my lord, the Honorable Judge Abhijit Ganguly, cancelling appointment of 36,000 lordships are also insisting of the matter. They published a my lord list where we have been shown not trained, but in the untrained category.
Violation of the earlier direction of
Violation of the, they are accepted me as trained, they are given me appointment as trained, but they are given me A category scale, they are given me all area dues, I have no grievance, but accepting that you are printed something which will go contrary to my status.
Now they have printed what?
in 20, as per the order of court, they have given the list of successful candidates or list of panel, entire panel
In that matter.
in that matter. And that matter, my lord, they have published a list showing the list
Same
of
as showing you as
board,
untrained.
board. Showing that these are the categories of candidates, some trained, some untrained.
Untrained. You are
shown as trained or untrained?
I have shown as untrained in spite of joining as trained.
Why, Mr. Vishas?
Thereafter, my lord, I filed a writ petition before this honorable court. The honorable court said the defense was taken that same issue is involved in the appeal pending before the division bench against the 33,000 cancellation of primary school teacher status, untrained teachers. That was untrained teachers altogether. But that time, my advocate, the petitioners were confused as to whether this issue is also a issue there in that court. But that particular issue, could not say anything about the same in 2024 order. Justice Vishwajit Basu's order. Thereafter, matter was returnable before Justice Chatterjee in 2025, where I personally appeared and addressed your lordship by saying that this issue is not the issue before the division bench, because they are the untrained matter. These are the persons who are already been treated to be trained. Therefore, it should be separately heard. The court adjourned the matter till the matter is heard by the division bench. So we spread for, but ours should be have an independent cause of action. Therefore, it has no connection with this. There was a number of writ petitions which were taken up by the honorable court in the sitting singly. The court declined, but since the other court already in the interim stage.
What is your problem, Mr. Bhattacharya? Then you are
against which we have preferred an appeal. Appeal, where we said that we are separate writ petition. We are not supposed to be tagged with the 33,000 cancellation issue. They are untrained candidates. We are not untrained candidates. In the primary of 2016 selection process, we are trained candidates. Therefore, our only status should be treated to be trained in view of the fact that we are being treated by not only by court but the authority themselves have also accepted me as a trained. Therefore, we should be heard separately.
pertaining to that
Untrained. We have been shown as untrained. We division bench we went. The division bench already passed order out of 3 matters or 4 matters. In 1 matter order has been passed. Other rest for the passes are there. Order Priyanka order.
Order passed
by Justice who mentioned sitting in the division.
What his lordship said?
My lordship allowed the appeal. Allowed the appeal directed to give the status of a trained person with all benefits right from the date of judgment passed by the honorable court.
But here court directed refixation of your salary.
Refixation of my salary because I was there. In that case, I was not given the A category scale from the date of joining. But here, as that has already been given, I am only wanting the change of status. Only a change of status, not as untrained.
No, that change of status has not been declared by this appeal court.
This court said that you are entitled to be treated as trained in view of the judgment passed by the court.
Where is that? Where is that? Treated as trained.
Yes. Paragraph 6.
Then, Mr. Vishas, why you are standing in the way?
I'm not, the facts, factually, just to inform your lordship, my lord.
No, Mr. Vishwas, you go through this order.
My lord, I have.
He was there.
I was there, my lord.
Then what is the difference, Mr. Vishwas?
My lord, if my learned friend wants this order, my lord, I am not in the way to, my lord, oppose. Your lordship pass this order. My lord, only one
Or
thing your
here,
lordship
my
kindly see, page 174 of your lordship's brief, my lord, stay application. What he wants more, my lord, I really fail to understand. Your lordship kindly, my lord, wants your lordship
174.
174.
যেটাই ও বলছে
My lord,
কথাই
on the
বলছে।
basis of apprehension, read cannot be maintainable.
No, what?
If 32,000 appointment goes, then my appointment will go on the basis of that apprehension. My lord, read cannot be maintainable. My lord, subject to my lord consideration. My lord, your lordship kindly see 174. This is the appointment letter of the petitioner. Your lordship kindly, my lord, top right, right hand side top.
Trained candidate.
Trained candidate. He was appointed as trained candidate. What he wants more, my lord? I am asking myself.
ও নিজেই গলাটা ঢোকাতে যাচ্ছে।
No, they have given the, my lord, list in terms of order of justice. Justice Abhijit Ganguly.
My lord,
that they are indicated us in the untrained category.
Where do we?
That list is there, my lord, at page 161 onwards. আমাদের নামটা কোথায় পাবি? একটা বার করলি না?
161.
161 to, sorry, my lord, 187 to 190. 190. Well, I have given an instance.
Just a moment. Are your instant, you have not, your names are there, not there in 187.
187, third one is my name. Printed page number. There are two page number. Printed, 187. The fifth one is Priyanka Chakraborty's name is there.
Priyanka Chakraborty is, he's para teacher.
Not a para teacher, he is a general teacher, matter that was wrong printed by them. Subsequently, they corrected it. I don't bed in him.
Now, what is the wrong? This is a
Trading score, no nothing. Trading score, nothing.
Pardon?
Untrained. Shows a category untrained.
Please read the first line. Breakup score of panel for the recruitment process of 16 against 42,949 in respect of each empaneled candidate.
Yes.
So where do you have shown as untrained? কোথায় দেখাচ্ছে?
Here is the train qualification, my lord. Number has been given against the training. Kindly come to the column number. 1, 2, 3, 4, 5, 6, 7. Training score. Lordship will get it. Mark it, my lord. Training score.
Yes.
Training score, my lord, we are nil. There are some training score given because they are trained. They have been treated to be trained.
So you are Priyanka Chakraborty.
No training score has been given to me. No training score has been given to me. Therefore, my lord, I have been continued to remain in an untrained category. This is a trained, untrained, mixed panel.
Just a minute. Para teacher.
Not para teacher. He is a regular teacher. Not an assistant teacher. That was wrongly given, for which the appointment was deferred for 2 months to correct it.
So how many petitioners are before us?
4.
Where are one is Priyanka, another is
Devdulal, Priyanka, Bhashwati আর আনন্দ।
ওট কি বললো? এই অর্ডারটা কোথায় আছে?
যে মেমো কপি। খালি মান্থ লিস্টটা পাঠিয়ে। Month list of December because that
চক্রবর্তী আমরা তো চক্রবর্তী।
দেবদুলাল, প্রিয়াঙ্কা, ভাস্বতী, আনন্দ।
These names are there, my lord. It is very difficult to find out. No one, my lord, we could not, my lord, even it has no serial number even.
It's easier for us to find out, na? মামলা ফাইল করবে।
No one.
আমরা চোখ খুলে চশমা খুলে দেবো।
আচ্ছা, পিয়ালি পেয়েছিস কত? কত? 162, 188. Trust me, get second one.
Just let us answer. If he is a para teacher, in that case, training will be there. That you are arguing, training will be there. Only aptitude will not be there, it will be experience. But training will be there.
Then he was, my lord, appointed as trained candidate. My lord, this is not the issue, my lord. Your lordship, my lord, subject to your lordship's kind, my lord, consideration. My lord, need not to, my lord, go into this aspect. My lord, he was appointed as trained candidate.
Grateful, my lord. Nothing further to be argued, lordship, I record that. He used to be treated to be a trained candidate.
I am nobody to say, my lord, the appointing authority
Yes.
council, the appointment letter, my lord, email, my lord, my lord, he was appointed as trained candidate.
Page
But
174.
training marks have not been awarded to me,
No, no, marks has been awarded,
but not shown.
not shown.
Yes, kindly, my lord, record that and dispose it of. I have nothing to further to say. There are also delay on identical delay in the other matter also, my lord, because it is arising out of the common order. A delay was conducted, my lord, on the by justice on other division bench. It
No,
is
no,
out,
show us your prayer in the writ petition
yes.
to rectify anomalies as reflected in.
Our prayer in at page 49.
Uh,
Our prayer in writ is page 49.
rectify the errors anomalies as reflected in the notification of breakup. That breakup sheet has been filed in that case.
Earlier case, my lord.
Earlier case,
There the cancellation of appointment was given in respect.
32,000.
Yes,
That
madam.
matter,
That-
this has been done.
Yes, yes.
Now you have come up against the appeal of 4th November.
Appeal of phone number 20.
4th November matter has been placed in combined list.
Yes. No, this is not the, my
No,
lord,
no, no.
level order, my lord.
Not an appeal.
No, not that is not the issue, my lord. Where the court said that it sees
That
the
is that finding, Mr. Bhattacharya, is subject to correction. That has to be returned by the single judge. If the single judge say no, in spite he had been very fair. He says that if you are a appointment letter shows you are a trained candidate, you only want an observation of the court that you will be treated as a trained candidate, irrespective of how you have been name has been indicated in some other list which was prepared. This is your apprehension. So you come to that after the writ court does not give you that prayer.
writ court subsequently also matter came up.
Combined list combined list, you come.
Subsequently, my lord, this was directed to to wait till the decision of the division bench on the question of 32,000 appointment. That was the prayer, and this is involved in that matter. They have to wait there.
Mr. Bhattacharya, what will be the suppose if it is to await this, unless the court makes an observation, tentative observation that yes, I will not give that declaration because something is wrong there. If the writ court says, then you come up in appeal before us.
This has already been intervened by the division bench, my lord. This has already been intervened by the division bench.
Mr. Bhattacharya, if we have understood you correctly, you are saying that everything is okay. Only my name has been shown there as an untrained candidate.
That is.
That, Mr. That goes contrary to your appointment itself. So you, to remove that doubt from your mind, you came to court and said that, sir, please say that I do not belong to that category. This is your
absolutely.
So mention it before the court as to be mentioned and get that order.
I could have tried, but this cannot be tagged with the 32,000 matter.
32,000.
The court has said so.
Not well.
Well, the order impugn, kindly look at
the order of the division bench. In favor of 32,000, they will, I believe, they will not place this matter, further. If it is goes against 32,000, then only, their cause of action will.
No. I am not concerned about 32,000. I am not untrained. That was relating to untrained candidates only.
This is the actual cause of action.
When second time the matter came up before this court, when I also wanted the matter, my matter be independently disposed of. Page 9 is the, Lord, should we look at this order? the relief sought for. I have no, my case, no bearing on the relief sought for. And I repeated the said prayer before the other court when returnable date. Returnable matter just with the copy was made returnable. There also could decline to not take up the matter.
Where is that order, Mr. Bhattacharya? A coordinate bench concluded, paragraph 3. Oh,
That concluded means by the order impugned order. This is the order of 4th of November 24, page 9 of your Lordship's book.
yes, where it has been said that it has a bearing.
First line, second line.
The very first sentence. Outcome of the case appeal before of the having a bearing on the relief sought for. In these writ petitions, as such, the hearing of the matter is adjourned. Therefore, it has a bearing on the relief sought for in the appeal pending before the court against 32,000. This has no connection with the 32,000 issue. Actually, we
This writ petition, that same writ petition,
yes.
Devdulal Acharya.
Yes.
Devdulal Acharya has already been,
Given the order.
then why Devdulal was added in this writ petition?
No, we have not added that writ petition. Devdulal was appeal has already passed an order in Devdulal.
So in that case only your other persons were not there with
No,
Devdulal.
not there. The different writ petitions, Lordship will get that cause title. Now Priyanka has come up before your Lordship. Writ page number 9, Priyanka's writ petition was there also.
So Priyanka is not similarly situated with Devdulal.
Similarly situated with Devdulal.
Then
But Devdulal had a less meritorious case. Devdulal joined prior to the judgment of the Arijit Banerjee. Devdulal was subsequently given the benefit of this training qualification after the judgment of
now after that Devdulal was not given the A categories case.
Yes, he has been given a category.
Then why the Justice Sen, why in that order is saying that we direct the state to refix the salary?
Area payment and all these issues are there. Fixation of salary was otherwise.
Then if Devdulal's was refixation, that does not become a similar cause of action in your
Because
case.
Devdulal's appointment was as an untrained candidate prior to the judgment passed by Justice Arijit Banerjee. He was supposed to get the benefit of this training qualification at the time of his initial appointment, from the date of initial appointment. From the initial appointment, Malad was made sometimes in February 2017, judgment came in March 17. Thereafter, Devdulal was given the special education benefit. But we were appointed after the judgment, treating us as a trained candidate. No problem is there.
Just when the recruitment process initiated, this person having the qualification of DLED special. So that qualification was not considered by the board initially when the panel was prepared. The group of writ petitioners came before this honorable court by filing a writ petition.
That is Justice Mantha's order.
No, that's the Arijit Banerjee's order.
In the meantime, pending of the writ petition, the appointment, the panel was approved and appointments were made. So what happened, my lord? Some of the writ petitioners or those who having the qualification of DLA special also got appointment as untrained. Am I clear to your lordship? As untrained. But after their appointment, the judgment came from this honorable court that this qualification to be treated as trained candidate. So therefore, after that order, 1st March, the appointments were made as a trained candidate. But
after that.
But in the meantime, those who were already appointed, they were appointed as untrained candidate. Without adding their marks, they were empaneled. Without adding their training qualification, they were empaneled. And therefore,
so what is they have been remained as untrained?
No. Since the appointment were given as untrained candidate,
Right.
but subsequently all the benefit of trained candidate because they need not to undergo further training of 2 year DLA. which was done by the other petitioners or other candidates. But they already had the training qualification, B.Ed special. So that is why, my lord, as soon as the order was passed, they were given the, my lord, training benefit.
All their, Mr. Biswas, all their appointment were given after the judgment in Sarthak's case.
Yes.
These
In this matters, all are given.
after
So that is why you have rightly given them as trained candidates.
But what my learned friend is saying, my lord, that before that the panel was prepared. Before that panel was, my lord, once
But before the judgment delivered,
before the judgment delivered, the
at
panel
that
was,
time they were trained, untrained.
and what happened, my lord? I tell you, lordship, factually, my lord, the entire panel was, my lord, sent to the, my lord, all the, my lord, district primary school council, all the, my lord, the different districts, my lord, and, my lord, the panel was published, my lord, the various, my lord, district primary school council
In which they went as untrained.
And, my lord, the list of the, my lord, the panel is also with the, my lord, the board. My lord, as soon as the order was passed by Justice Gangopadhyay, you immediately, my lord, upload my lord, we had no other alternative but to, my lord, upload without verifying anything. And, my lord, at that point of time, we had no, my lord, the machineries or anything to, my lord, verify or, my lord, whatever. My lord, we, my lord, uploaded it to save the, my lord, other consequences. My lord, this is the position. That is why, my lord, this, my lord, confusion or, my lord,
retrospective effect দেওয়া হয় তাই তো স্যার ঠিক বললাম সেটা নয় ঠিকই বলেছিস কিন্তু এই প্রিয়াঙ্কা ছেড়ে দাও
Order. That was the observation of the court. Second time also the court did not entertain.
Therefore, it would not be appropriate to hear the matter before the matter is heard this way at this stage.
So what that particular finding is wrong. That particular finding, my lord,
How does that infringe your right? Tell us one thing.
this appeal matter cannot, my lord, a condition
Then we
precedent.
will say that your anticipation is misconceived. We will dismiss your appeal, recording that this is a misconceived submission which is being made because we do not find any reason that the board is treating you as an untrained candidate.
Board is treating the my learned friend what has said to your lordship that initially they filed
Forget
the.
about that. We will record that.
We have.
We will record that, but we will dismiss your appeal. Saying
My lord, my lord, kindly, this will cause a serious prejudice to us.
Then what we will do? Say
My lord, kindly,
arguing something which has not yet happened.
This particular.
You want it now. Appeal court should intervene and give the benefit. Devdulal is not similarly situated with us. We could have understood if here some scale has been withheld. We would have immediately.
That is not the issue even before the Devdulal.
So then.
Devdulal also a similar issue that we have trained.
was appointed prior to 1st March 2017.
1st March 2017.
These people aren't. And
this,
their appointment letter
this is a better case, my lord, where we were appointed
Correct.
after the judgment.
If it's a better case, you have a weak appeal.
But that is your lordship's mercy. But today, my lord, at this,
Mr. Bhattacharya, then what happened? Today, if you are serious with your claim, then you should go to the learned single judge with an application that don't treat me. You could not have included my name in that list. Then if the learned single judge dismisses it, then you can come to us that it is a this is the issue. No legal right infringed. What we will do?
legal right, my lord, but exposing me as an untrained candidate is a right, my lord, which I
Yes,
can
right.
avoid. That is in page 187 page.
187 is prior to.
No. That is wrong. That was published sometimes in 2023. That was as per order of the court in 2022. When I was appointed in 2017.
Correct. Your 2017 appointment is as a trained candidate.
Trained candidate. That's why even I am shown in 2022 as untrained. Kindly come to the opening page, page 186. That was a 2022, my lord, the notification. There also, my lord, I have been shown as untrained.
That is what Mr. Biswas is saying. Kindly come to page 186.
Yes, 186 is a page
On the basis of Justice Gondopadhyay's order, they published the list. They themselves are saying that we could not even check up at that stage that who is trained, who is untrained.
Kindly, my lord, record that and correct it and we shall go. My lord, kindly, I have no further grievance, lordship. Kindly, my lord, record that and correct it. My lord, we shall go. My lord, kindly do not give us further pain, my lord. Already we are overpained on the issue. Only observation that they should be treated as trained as said by the board.
Where they have said they will not treat you as trained.
2022 circular, they have shown me as trained, untrained. And their reason for this, my lord, is something, my lord, which is their internal affair. But we could not, my lord, conceive to that, my lord, that we cannot accept that why should I be continued as an untrained since I have appointed as a trained. At least, my lord, give that protection to us.
Court says he's a trained.
Record that, my lord. Record that and dispose of the appeal that we are trained candidates. This is wrongly, my lord, recorded in their panel.
Getting a category scale since its inception.
It has not been, my lord, thrown to third round of litigation. After this judgment, somehow lordship is not accepting the untrained persons and we are panel, my lord, contain my name.
তিনটেতেই আছে একই মামলা 18, 19, 20
তাহলে আমাদের বলতে
taken on a leave মিলার না বলে যাই না বলে হবে না আমার তো কিছু বলার নেই না may I take on a leave and just coming within 2
Mr. Biswas, can we record that even if their names are there in that, they will be treated as trained?
Lordship, record is declared it, my lord. My lord, we are not on the, my lord, way stand.
Grateful.
What is the fact? My lord, I placed, my lord, I submitted.
No, why? Because page 186, 187 you showed na. 186 is of a memo dated 28 November 2022.
My lord, I submitted, my lord. 186 is the outcome of the order passed by the single bench.
Yes.
My lord, whatever we had, my lord, we uploaded it.
No, but at that time, Justice Mantha's order came when?
No, Justice Mantha's order, no way, my lord, here is.
Justice Orijit Banerjee's order, 1st of March 2017. And I was appointed in April 2017.
I didn't follow. What did you say? 1st of March?
March 2017, Justice Orijit Banerjee declaring the special education is a training qualification.
Oh, that was not by Justice Mantha?
No. Justice Orijit Banerjee. The judgment is annexed.
Where is that?
Judgment is annexed. Justice kindly Orijit Banerjee judgment, my lord,
your appointment
at page
was after
104.
this? Your appointment was after this?
After this. That was made after this.
Page
Page 104, the judgment starts, 1st of March 2017.
104.
And operative part at page 147. Last paragraph, Lordship may read below, that will cover the issue. So 104.
Now, this notification was after Justice Murijit Banerjee's order.
Note that your lordship 172 page 140 one page the correct sir 172 my lord. My lord,
Yes.
last part my lord, paragraph 55 52.
Yes, ঠিক আছে.
My lord, at that point of time my lord, we apprehended
70?
173.
2.
my lord, the paragraph 52.
Yes.
My lord, Mr. Gupta had indicated that in the case the court now holds that the petitioner should get the benefit of being treated as 10 candidate, it will create huge logistic problem for the respondents. The major part of the vacancies have already been filled up by issuance of the appointment letter. My lord, we apprehended that. My lord, at that point of time, 2017. My lord, when the single bench directed board to upload the my lord, data or backup of court, my lord, that after lapse of my lord, publish of the panel 4 years, my lord, the investigation was going on. CBI, ED, my lord. All the board my lord, were under the control of the ED and CBI, my lord. My lord, no one of the, my lord, the member of the board or my lord, the officer, my lord, the officer or the staff of the board were not in position to scrutinize or were not scrutinize this. My lord, that is why, my lord, this was uploaded and my lord, this was done. But because it was, my lord, done in the year 2016.
No, my name cannot come there because I was appointed after that.
22.
Yes, 22. My lord, what is the 22? This is the nothing but a list,
Breakup of marks.
breakup of marks which was prepared in the year 2016. But that was only uploaded in the official said we asked from the malad the our agency and malad we get it and malad uploaded it. This was actually happened, malad, and that point also malad I just shown you lordship malad. It was our apprehension also malad. If something will be malad problem will face some problem malad. We apprehended that.
Records reveal
almost same. They joined only
Factually, my lord, different, my lord. Factually, my lord,
joined prior to the judgment, as was the subject matter before Justice Shaw mentioned.
Which one? Item number 19.
19.
19 and 20.
19 and 20, what happened? They had joined.
Joined prior to the judgment passed on 1st of March 2017 by Honorable Justice Arijit
Oh,
Banerjee.
acha. But
Thereafter, they
at
have
that
been
time
given.
also they came within the zone of consideration as untrained.
Considering, without considering training marks, they were untrained, they were joined as untrained, like 32,000 your lordship is hearing, my lord, but similarly different in this case, my lord, because my lord, they were undergone training after joining, but they had training when he joined, but they were
Oh, they completed 2 trainings then.
no.
No.
They did not undergone further 2 years training. The right
Huh, সেটাই। See,
present appellate.
but their appointment was prior to Arijit Banerjee's judgment.
Their appointment was prior
And
to
at that juncture, they were appointed as untrained
untrained
candidate.
candidate without considering the training.
When the writ,
Now, subsequent to the writ petition order, they were granted, they were treated as trained and were given the
A category scale.
Scale of
A category scale.
but
আচ্ছা,
initially
এখানে একটা
our
নোট লিখে রাখো
record
ওটা,
says, my lord, he was appointed as untrained.
এখানে একটা নোট লিখে রাখো ওটা পেন ড্রাইভে পাঠিয়ে দিয়ে ওই কারেকশনটা করে দিয়ে দেবো। হাউ মেনি পিটিশনার্স আর হিয়ার?
3 petitions.
My lord.
Only 3.
When are their
they-
appointment letters?
Kindly come, my lord, to
Here also they were shown as untrained.
they are shown an untrained, my lord, because
Rightly shown.
that time the judgment did not come, did not see the light of the day, because when we joined as untrained candidate, we qualified in the
বুঝেছি রে বাবা, অ্যাপ্লিকেশনটা দেখান না,
Page
অ্যাপয়েন্টমেন্ট
128.
লেটারটা দেখান।
but kindly come to
এর অ্যাপ্লিকেশনটা
Page 128. কোনটা দেখছো? এটাতে কোনটা? আনন্দ সাময়িক।
this appointment letter, page 128.
আমি ওটা করে দেবো।
হাওড়া কাউন্সিল।
Appointed as assistant, this was untrained.
Untrained, because 12th of February 2017, judgment came 1st of March 2017.
আচ্ছা,
appointment
Only
17
10-15 days before I got the appointment.
আচ্ছা এখানে লিখো ওই লাস্টে একটা প্যারাগ্রাফ লিখে দেবে কিংবা একদম প্রথমে একটা প্যারাগ্রাফ। In the present case, the appellants were appointed prior to delivery of the judgment in the case of judgmentটা কোথায়?
Judgment, my lord.
At
Judgment
page 104.
delivered in the case of Sarthak Ghosh and others on 1st March 2017. আর ওদের appointed যেটা দিয়েছে না ওটা ব্র্যাকেটে লিখে দেবে page 120, page 128. Where are the appointment letters? Page 128.
128, my lord, then 130 and 132.
128, 130, 130 করে দিয়েছে।
দেখে দিচ্ছি
Stop.
তোমার জন্য, সবই দেখে দিচ্ছি।
all same
তুমি খালি একটু মানে
Same
আমাদের
deal.
নজর দাও, তাহলেই হবে।
They emerged to be successful in the selection process of the year 2016 and were accordingly appointed as untrained teachers. Subsequent to the delivery of judgment, bracketed page 104, which was not appealed against by the respondents therein, and in compliance of the same, the appellants were treated as trained candidates and were granted the appropriate scale of pay. বলে ওই নোটটা লিখে দিও, তারপরে ওই কারেকশন গুলো অ্যাকর্ডিংলি করে দিতে হবে। তো এই পেন ড্রাইভে পাঠানোটা করো। আর where is the order impugned? Here also that এখানেও সেম আছে। ঠিক আছে। Disposed of. Next টাও same করে দেবে disposed of.
next
next
one,
টার
my
page number গুলো কি? Next
আচ্ছা।
item number 20. Give the page number.
Page 221, 261.
হ্যাঁ
221 to
next টাতে
261.
next টাতে appointment letters at pages
221 to 261.
221 to 261.
Yes.
কতগুলো লিখবে?
কতগুলো?
ঠিক করে বলো
13 persons are there. Joining and other documents are there.
Plain appointment letters given in pages
221, 247. Kindly, man. 247
ও ভুলিয়ে ফেলছে, এতগুলো আমাদের অর্ডার পাচ্ছে না, মাথা খারাপ।
up to
72.
You have a great day today, Mr. Bhattacharya. Huh?
a great day, but great blessings of your lordship that I
Just
could
going
get.
outside the courtroom and we won't pass this order. এটা থাকুক এক সপ্তাহ বাদে।
Don't do this one. These are the only dates I'm doing.
220 pages.
That is the 247 to 272.
247 to
274.
274. 47 to
274.
আরে 274 রিলিজ অর্ডার দেখছো কেন ও
গুলিয়ে ফেলে যাবে না।
72 অবধি
release up to 272.
72 appointment letter দেখে নেবো ছিল। ওটা চেঞ্জ হয়েছে। They were appointed subsequently.
এই ক্যাটাগরি
এই category. 270.
অ্যাপয়েন্টমেন্ট এই যে
They were appointed,
271
but they were also appointed subsequent. They were also appointed prior to the delivery of the judgment of justice on Arijit Banerjee, and as such they were in
কতটা মেনশন?
appeal গুলো আসছে।
Lordship, item number 21. I am for the appellant. My senior is engaged before the landed court 8. Therefore, I am praying for not today.
Why you argue?
You start.
You start. What is the problem?
My senior is engaging before the landed
Let him
court 8.
be engaged. You start.
I have no knowledge about this
You
matter.
know about the matter.
No.
You know? What is
For
the
the statement.
what is the matter?
My lord, matter is regard to my lord marks obtained in the HS examination. The question and some wrong answers.
Post publication scrutiny. What he wants, the board is there.
Yes, my lord.
Mrs. Bhattacharya is appearing for the board.
Where is
She is engaged in court number 18.
not today?
Grateful.
Grateful.
So in respect to item number 22, my lord,
Yeah.
the court password, Mr. Shoaib Acharya on leg, my lord.
No, no, he is appearing after many days. We will take it.
Several dates, my lord.
No.
Nothing in the application.
Let me come.
Who is your senior?
My lord, no, he has been engaged. That is
Oh, engaged.
by the client, my lord. That's why, my lord.
What was the material instruction? Engaged. Yes, Mr. Chattopadhyay, what is the matter about?
But overdrawal, my lord, that has not been returned. Court passed the order. But pay fixation will be on the basis of actual pay. That has been challenged. That is settled law, my lord, because overdrawal amount has been fixed higher. So accordingly, it will not be returned. Court observed that.
No, overdrawal was accepted by them.
Yes, my lord. Overdrawal bole we have not deducted. Court of the
Not deducted.
not deducted.
Pay fixation was.
Pay fixation will be in accordance with law.
Justice Jyotirmoy Bhattacharya's
Yes,
judgment.
Ilagiri, 2001 volume 2.
তাহলে আর কি করবো?
Let him come.
দেখি ফাইলটা দাও।
ইম্পিউনটা করিয়ে দিন। আজকে বললো যে বাল সেবিকা which is not accepted.
They have obtained the Bal Sevika, my lord, as a PTTI. That has not been accepted, but however, when scale has been given.
You are getting pension now,
Yes, pension.
but in a lower scale of,
That
according to you.
that is.
That is your grievance. Yes.
What is the third person? He's on like from that building from 759. He's on like.
Every time, my lord, he is
No,
asking
every
time,
time.
my lord. Earlier division when he has taken the time. তো দেখছেই ওটা।
The present appeal has been preferred, challenging an order dated
Page 36, my lord, Government of West Bengal. 36, 37.
Now, Mr. Acharya, only one thing we are asking. Your overdrawal, alleged overdrawal has not been recovered. Now,
As per order of this.
as well. And court has said that your fixation was not proper. You will not get that A category fixation. So how can you be agreed by that? Because that is
No, my lord, the Bal Sevika, if your lordship have a look, my lord, this, my lord.
page 38.
Yes. Bal Sevika লেখা আছে কোথায় একটু যাচ্ছিস করো না
Yes, page 38.
এটা যেমন
Opposition report.
Bal Sevika training certificate. Yes.
But page 36, if your lordship kindly have a look.
77 order
This was Director of School Education. Non-formal education for the age to so and so, so and so.
37 Bal Sevika. 37.
And 37 is, my lord, the Bal Sevika Training Institute. That is also the West Bengal Council for Child Welfare.
আর ওই যে মেমোটা দেখাচ্ছিল ওইটা অ্যাকসেপ্ট করছি মেমোটা দেখাচ্ছি
And my lord,
কিছু না ঠিক আছে আর একটা কপি রাখো
Do you have that report of the DI? Affidavit?
The report in the form of it we have submitted.
You have copy, Mr.
Yes.
Our office. Why haven't you now annexed that?
My lord, kindly have a look, my lord. Page 62 and 63. This was dated 26th of June 1965.
It has been considered.
54 notification, Mr.
Yes.
65 notification.
এখন তো modern technology.
And then, my lord, the 64 also. Page 63. This was
Where you were appointed in 1993.
Yes.
So you were given what scale of pay?
My lord, the A category scale of pay throughout my service.
You got A category scale throughout.
Yes,
So
on the basis of this certificate.
your qualification was treated to be a trained qualification. Where do we find that trained qualification? Your appointment was 93.
93.
At
But
page
if you-
64 is your appointment. You were given 1040-1920. This was an
No,
A category
initially, my
scale.
lord, initially page 45, if your lordship kindly have a look. Page 45.
20.
Mhm.
Impaneled.
96. This is 1996 memo, page 45.
Page 45, initially, my lord, without, my lord, taking into consideration, my lord, the Balsevika training. 980, 1755. Then, my lord, next page, if your lordship kindly have a look. Then, my lord, I got, my lord, the
Scale to be read as 104.
104.
This was 1996.
1996.
Your appointment was 93.
1993.
On the date of your appointment, you were not given the A category scale.
No. Subsequently, it has been, my lord, rectified and, my lord, page.
This 1040 is the rectified pay scale.
Yes.
And you retired. Now, page 47, what is that?
My lord, this is the my lord, the approval. My lord.
Approval was also in scale.
2009.
Your scale is not reflected here, page 47.
47, no, scale has not been.
Achha. It refers to page 6. It refers to page 65, na? 62, 57 AC. 57 notified 2002.
See you that she is not entitled. That's just
Page 47.
Yes.
This notification of 15 January 2002. Where is this notification?
This notification here is, it is not.
তো সেটা তো লাগবে. On that basis, you have to see now what was the scale event. Why you are referring to page 62.
Page 62, my lord, the 65 memo, where it has been recognized as a training certificate.
Now, Mr. Chattopadhyay,
But Lordship kindly go through the judgment, my lord. That was in detail, my lord, that has been discussed.
which judgment?
Judgment passed by the trial court.
Page 77. Page 77.
Paragraph 5.
Paragraph
No
See, my
detail.
lord, paragraph 3.
That is a judgment in another case of Guwahati High Court.
Yes.
That is where
What relevance does it have with this?
The certificate is not recognized even
This,
for the
the reference, my lord, I have tried my level best, my lord, to get it. But
So where from did who gave it? Mr. Chattopadhyay?
no, no. This is on motion of my lord, Justice Mantha has referred.
You have not got this judgment? তো হতে পারে না। সাইটেশনটা ভুল হয়েছে হবে।
পেজ 2 প্যারাগ্রাফ।
No, this judgment, my lord, I really, my lord, I could not find it. 2005 one GLR
When petitioner joined in,
Now, my lord, if your lordship kindly on the
when
stage.
the petitioner joined in 1993, that Balshevika is no more. At that time, like PTT has come, PTT.
But
That is
you
the of the
revised her scale of pay. 96, you revised the scale of pay.
but training qualification is not all we have given benefit. We have given benefit. But that given mala that has wrongly been done.
Wrongly done for 30
For
years.
this we have not deducted. But according to
that is as per
retirement
order of
time,
this court.
mala he is entitled according to what is the law. Law is mala actually he is entitled. That is the settled law. If he is actually entitled.
Show us that he is not actually entitled, Mr. Because on 1993, you gave him the right scale of pay according to him. You yourself revised it and gave. And where is this judgment?
My lord, I think, my lord, Mr. Chottowa take instruction at page 49. Kindly see the similar circumstances, my lord.
Maybe that
on the
if wrongly
he has given, my lord, this.
wrongly that cannot his right. According to his perpetual right that wrong should be committed.
Mr. Chottowa, come with a short evidence. The present appeal has been preferred. You are getting pension, na?
Yes.
Present appeal has been preferred. Challenging an order dated 18th of April 2024 passed by the এইখানে অর্ডার শিটটা রয়ে গেল Yes.
Improved order is dated 5th of February 2024.
Page.
That is the last page of my stay petition.
79.
Page 79. I had deficit qualification admitted. No one is disputing that matter. I contested for the post of headmaster. I required 50% in the postgraduate, which I did not have. I was directed to appear in the interview. At the interview level, I was made not. Because I had the marks above 45%, not the 50%. But I am relying on a decision of a pending proceeding before your lordship on the issue, because in the Madrasa Service Commission, you are taking 40%, and in the government schools, you are taking 45%, and so far as the private schools are concerned, sponsored aided schools are concerned, you are asking for 50%. This issue has been entertained and court has fixed the matter. Matter is appearing in your lordship's list in the combined list. Yes. At pitch.
Yes.
Item number 35 in the combined list. Matter is appearing. This issue is being considered by the division bench. If I be given an opportunity to have the matter tagged with this matter, so that the matter once decided, I can get the benefit of relaxation of my
So that matter is what?
That is the identical issue, my lord, where the
Whether 50% cut-off marks can be set by the commission.
yes, can be relaxed by the commission, because in other madrasa it is 40%, and in government school it is 45%.
But the commission is not commission has set on the basis of the state's direction, maybe.
That is exactly the issue is being considered. Why don't you relax it? May I place
No,
it,
no,
Madam?
the issue involved in those matters is not the question of relaxation. The question is that when the cutoff was originally 45, how could you have enhanced it to 50? The learned single judge has held in our favor. It was done prior to the advertisement, the amendment of the rule, so the learned single judge accepted. That matter is before your lordships. That is the matter which my learned friend is showing.
And this one?
But the relaxation, that 50% is the cutoff, but we can relax or we should relax, that is not the issue involved in those matters. And the subject matter of the writ petition.
Division bench order that I handed up to your lordship. Primary and only issue in the appeal whether the respondent school service commission stand justified imposing 50% cut-off marks for recruitment of headmaster in government aided school.
That is higher.
Jaha advocate so and so, my lord, 50%, and it is submitted that no tangible reason has been made out by the respondent SSC to distinguish the difference of cut-off marks, that is one SSC for both PSC and the Madrasa Service Commission, except the higher standard of merit is required to be factored for the recruitment of.
Dr. Patru, you file an affidavit, we place it along with that.
But the question will be different. It will enlarge the scope of arguments in.
No, we are not saying analogous here.
Very well, very well.
As you know.
Very well.
You use a writ petition was on affidavits.
No.
File
The prayer also in the writ petition is different. The
Lord, he
petition.
obtained that 50% in a degree subsequently acquired.
Yes. Here
The date of application, he was below 50%.
Right.
The
Yes.
MA that he relied upon was below 50%.
Yes.
Sometime in November, he acquired a second master's in which he had about 50, he had about 60%.
Yes.
So whether that can be considered for the application which he has made prior to.
Before interview.
Yes, that is what I was trying to submit, that the writ petition also has been filed on a totally different context. That I have got a subsequent degree, let it be accepted. That we will object to, because the rule is very specific.
On the date of the application.
On the date of the application. And this is his third MA degree.
Correct.
His third one.
The two he gave.
Two he had which did not help him.
3 MA degrees, but not a headmaster. What else I can
Two
do?
below 50. Two of them below 50.
Two below 50, another
Third
60
is
point.
60 point something.
How long one can have a battle like this?
Not today, take it.
In case it does not reach tomorrow, kindly extend the entry mode. In case it does not reach tomorrow,
উপরে রেখে দিও হ্যাঁ এটা কি উপরে রেখে দিতে পারবে Mr. Bharat Singh is there. Application head একটু উপরের দিকে রেখে দিই একটু উপরে
With regard to this 2 p.m. fixed matter, which your lordships are hearing, if I may just trouble your lordship once, I have on the bunch of the applications with this appeal, but I have an application number 26, which is for an addition of party. But if your lordships, if there is a ballpark idea when the applications will be taken up.
Pardon?
Well, there is an application item number can 26, which is
Remind us on the next.
lordship. Next.
Hello, am I appearing?
Which is the application?
Yes.
Which is
number 26. One of these applications below your lordship. Item number 56. Below that, there is a can 26 of 2024. Lordship. I'm deeply obliged to your lordship.
56.
26. List है ना? What line? Item number 56 है तोला है तो मतलब in 873 of 20.
56 से तोला है ये क्या नहीं?
लिस्ट देवे ना मैं देखिए दीजिए.
4 नंबर लाइन है क्या?
This is in connection with which appeal?
मतलब MAT 873 item number 56.
In appeal. Order
26 of 2024.
Yes.
Lord, I'm deeply obliged to your lordship.
May I please? I am appearing in my lord MAT 1873 of 2023. This was my lord was allowed on the leave to file appeal was allowed on my lord 12th October. And my lord, I am not appearing for the para-teachers. I am appearing for the trained candidates who had been, my lord, no, I am appearing for the untrained candidates who have subsequently, my lord, trained themselves. Lordship, may I just?
You're appearing in which appeal?
My lord, MAT 1873 of 2023.
How many appellants are there?
My lord, how many applicants? 30 applicants.
Yes, they are what you said?
My lord, we are similarly circumstanced 21 applicants. We are similarly circumstanced as the clients of
21 applicants?
Appellants.
21.
21 candidates.
Just now you said 30.
No, my lord, 21. I stand corrected.
You joined and thereafter got training?
Yes, untrained, joined, now trained. Now, my lord, on the last
Did you complete your training?
With all the other persons, my lord, my training in respect of one of the appellants is in May 2019, training certificate.
May 2019. Yes.
Diploma in elementary education. Now, on the last occasion, Mr. Shen has, my lord, demonstrated before your lordship with regard to segregation. Now, my lord, my endeavor today will be to further segregate ourselves from, my lord, the allegations made in the writ petitions with regard to the dates scam or whatever, however it has been described in paragraphs 12 to, my lord, 17 of the writ petition, 12 to 18 of the writ petition. And that has found one mentioning in the impugned order at paragraph 17. Now, my lord, may I just demonstrate before your lordship, my lord, from the convenience brief, my lord. I'll try to segregate the TATE and the, my lord, recruitment process. Kindly takes up my convenience brief, my lord. 3 pages I'll draw your lordship's kind attention to. Page 20A is the notification of TATE. pursuant to which, my lord, everyone has appeared.
Yes.
Yes, my lord, here Lordship may kindly remembers there is a recording in the orders passed, my lord, by the Honorable Judge in other proceedings which Mr. Shane had drawn your Lordship's kind attention to. 23 lakhs has participated in these proceedings. It has been submitted by Mr. Gupta. May I just place once? That-
23 lakhs candidates participate.
Yes, state. That has been recorded.
In which? 23 lakhs in the recruitment
In-
process?
No,
Or in the
TATE 2014.
Yes.
Yes. May I just part? In continuation of the notification read with such and such.
Where you are reading?
My lord, from the notification for application for forms for TATE 2014, page 20A. 20A. From my compilation. It's 26 June 2015.
Yes.
Now, my lord, in continuation of your notification dated such and such, with the corrigendum and addendum, notification dated such and such, all concerned are hereby notified that application forms for TATE 2014 will be held on 30th August 2015 from 2 p.m. to such and such throughout West Bengal, will be available on 29/6/2015 to 4/7/2015 from the following distribution centers on payment of 100 rupees only and 25 only for SC, ST other categories. Eligibility: a person who has passed HS or its equivalent examination, 50% marks, 45% reserve categories, or has been graduated irrespective of the percentage of the marks in such graduation examination from a recognized university. It is only eligible as per the aforesaid notification. Thereafter, important notes are, my lord, the TATE 2012 candidates who have already confirmed their candidature online in terms of the notification on 26/2/2014 and hold the downloaded acknowledgement receipts along with original TATE 12 admit cards must not apply. So therefore, they can participate. The persons who had participated in 2012 TATE but has failed, they can again participate. They don't have to fill up. Third is,
Failed in what?
they don't have to fill up the form of TATE 2014.
So this was open to 2012 date.
Open to persons who had participated in 2012 TATE and might have failed or may participate. So therefore, they could have again participated.
Participated in the recruitment process.
2014 TATE.
Recruitment process is of this is state 2014 years.
Yes, persons prior to this TATE 2014, in 2012 another TATE was held. So there might be
notification for
TATE
TATE
2014. 2014.
What you are showing from?
My contention is that TATE 2012 candidates could have also participated and that they had to indicate that they had participated in the TATE 2012 in the OMR sheets in the examination halls.
So
That
how
is,
does
my lord.
So what is the significance for
Significance is that, my lord. Significance is that, my lord. Whatever with regard to the OMR sheets are relating to the TATE examination, which is not subject matter before your lordship. That is what I'm trying to substantiate. I will show another notification and thereafter take your lordship straight away to the order where the OMR sheets are.
What is your pleading? That this marking of training was there, etc., etc.
This is appearing from this record, sir. This is appearing from this record itself. From the
We
TATE.
don't follow your argument. Your argument is state 2012 candidates who failed. They are also open to participate in
Yes.
TATE 14.
Yes. This is as it appears. I am just placing the entire document. So therefore,
what
my
you are-
contention is that anything with regard to the OMR sheets.
Where from we will get this OMR marking you are saying? This
In the
OMR marking
written examination is only in respect of TET 2014. In the recruitment process, there is no written examination.
Yes.
So the fact that OMR sheets are being considered in TET 2012, 2014, that is why I indicated the mention of the OMR sheets in this notification itself.
Where is that?
Third, TET 2012 candidates holding admit cards and downloaded acknowledgements will be able to update their respective categories, DLET training, etc. in the OMR sheet in the examination halls. My contention is that whatever OMR issues are there are with regard to TET 2014 and not with regard to the recruitment process. And another thing, a candidate who will appear in TET 2014 from any district, if qualified, will get a TET pass certificate and shall be able to apply for appointment in any district of the state. So therefore, a candidate who may participate from South 24 Parganas and passes the TET examination may be appointed in other districts also. And my lord, the district codes are there in respect of this. Kindly see there are district codes. So these district codes have been shown to your lordship. Now, my lord, kindly comes to page 34, where, my lord, the candidate who had participated qualified. Page 34, I have annexed a sample copy. Kindly see qualified. Result of TET 2014 qualified, and thereafter is the notice, page 35, from where it will appear that the results were declared on 14/9/2016, page 35. Kindly takes note of this date. 14/9/2016. And my lord, the RTI applications with regard to the OMR sheets were my lord invited, and thereafter on 24th, 26th September 2016, the recruitment process started. Mr. Shane has drawn your lordship's kind attention to the recruitment process. I will not trouble. Now, my lord, I'll be drawing your lordship's kind attention to the orders where this TET 2014 is being considered. I'm trying to basically segregate 2008, 2014, in respect of which several allegations have been made in the writ petition. And from this, the reference of scam may have cropped into the order passed by the honorable trial judge in the impugned court, in the impugned judgment. And I'm trying to substantiate that those observations in the impugned judgment are not relating to the recruitment process. Kindly comes to, this is the latest order which has been passed. This is the order dated 30th April 2014. Kindly sees 2004, sorry, 2004, 24, sorry. Shantanu sheet. Shantanu sheet. Kindly comes to page 7. These are the writ petitions. These are the writ petitions which were taken for consideration. Now, paragraph 3.
These are similar to Suman and those two judge
No,
orders which are
not similar to Somen and Ramesh Molli. Not similar to that. These are persons. Kindly see paragraph 3. The honorable judge has recorded. May I place, madam?
yes.
The subject matter of challenge in the instant writ petitions is the teacher's eligibility test, TET, conducted in the year 2014 by the board. the petitioners participated in and have found themselves unsuccessful in the state examination. A large number of litigations in conduct of the said state examination has been raised in the writ petitions. These have been broadly recorded in the order dated such and such and earlier orders. Further issues have come to the notice of this court after going through the affidavits of CBI. Several applications for impleadment have been filed in the writ petitions by the candidates who succeeded in TET 2014. Each of the said application in the connection are allowed. Leave is granted to the learned advocates for record for correction. Soft copies. I'll just skip over, my lord, paragraphs 7, 8, 9 and 10 and come to paragraph 11. The subject matter of several appeals being presently heard by the division bench of this court, inter alia in mat such and such, arises out of an order passed in WPA 21187 of 2022 Priyanka Noshkar versus the State of West Bengal, cancelling the entire recruitment process of 2016 are referred by the parties. So these were the appeals which were referred. The said recruitment process was based on result of TET 2014 conducted by the board. In the appeals in question, the order of single bench was stayed in part. The rest of the order of the single bench was eventually set aside by the Honorable Supreme Court in SLP dated such and such by 7 July 2023 order. This is the order pursuant to which we are before your lordship. Supreme Court directed the division bench to hear all the aforesaid appeals referred to herein above. The hearing is underway, referring to these appeals that I am appearing before your lordship. It is submitted by the parties that any decision in the instant proceedings would have a bearing on the issue pending before the division bench. Thereafter, the finding. This court is, however, of the view that the propriety of TET 2014 examination would still require inquiry in these writ petitions, irrespective of the proceedings before the division bench. So therefore, the issues with regard to the TET are different, which are being adjudicated in a bunch of writ petition, where the Honorable Trial Judge is in session of the, my lord, matters. In those circumstances, the court directs writ petition may list for hearing after such and such exchange of affidavits. So these are all pending.
Yes.
So therefore, any allegation with regard to the TET are not before your lordship and is pending before another honorable single judge.
Are these persons parties to this
No.
proceeding? Then
No, they are not. They are unsuccessful persons
in TET.
Who had approached with allegations in TET.
Hmm.
They are litigating elsewhere, and pursuant to the results of this state, 3 recruitment processes have been conducted. First, our recruitment process in 2016. Where this 42,000 odd has been recruited. 11,000. 16,500, 2020. Thereafter, another recruitment process.
Then what is your argument, sir?
Argument is that, my lord, TET 2014 is totally different. And, my lord, the allegations made in writ petition from paragraph 12, 13, 14, 17, which I will not place before your lordship, are with regard to TET 2014 and cannot be a part of these proceedings. That is my
Who
argument.
has told? Who has said that? It is not their submission.
My lord, it is, my lord, in the
Your argument. You are saying.
in the petition they have said.
Petition they have challenged in the made amendments as regards State 2014.
Means 2012 paragraph 12 onwards.
State 2014 issue is still alive. That is
Before
your
a division
contention.
bench, before a single bench.
That is your contention.
Yes, it is not before this division bench.
So according to you, TET 2014 genuinity is still under the scanner. That is what you are wanting to say.
My lord, my contention is that another, my lord, division bench, another single bench.
We want to know your argument.
Yes.
The State 2014 is already under a scanner and continues to be under a scanner in a pending writ petition. That is what
My
you're
lord,
saying.
my lord.
So how does that help you?
My lord, it helps
That
in view
goes
of,
against you.
no, my lord, it will not. Why I'm saying so? Because in the writ petition, in paragraph 12
Yes.
and onwards, may I just place one line of paragraph 12? Your petitioner states that recently TATE 2014 scam busted in West Bengal from several cases.
Yes.
So these submissions, these averments in the writ petition has swayed the honorable single judge to make observations with regard to the scam in paragraph 17 of the impugned order. So these averments could not have been considered by the honorable single judge. Here, my lord, the petitioners claim themselves to be TATE qualified candidates. They have not challenged TATE 2014. They cannot, because they have participated on the basis of TATE 2014 examinations.
Yes.
Am I being able to, my lord, substantiate, my lord, that this is two different things? So this may not fall within the scope and ambit of this writ petition
The
and this
present
appeal.
petitioners are all TATE 2014 qualified.
That is my contention. Now, my lord, next contention is that, my lord, Mr. Shane had drawn your lordship's kind attention to the orders passed in
petitioners hearing.
Yes.
Each petitioners who approached the court,
yes,
they were untrained but TATE qualified. But TATE qualified.
TATE qualified.
How does that help you?
It doesn't help them also. It doesn't help me. It doesn't.
you're
We are
arguing
similarly circumstanced. So therefore, the petitioners being TATE qualified could not have, my lord, criticized TATE 2014 examination, which they have done in their writ petition in the averments.
All the petitioners are TATE qualified.
Yes.
And as such, they cannot take any defense against
They cannot turn around and say that there is a scam in TATE and all these things. That is my contention. Next is the sequence leading to the passing of the impugned order. Now, my lord, Mr. Shane
repeated thousands of times.
One order.
Still want to show
one order which was not shown. My lord, I was there present.
Yes.
Kindly takes up the compilation and straight away comes to an order which arose out of the other two writ petitions which were being heard by the honorable single judge in the month of April 2023. My lord, the hearing in respect of our matter in this writ petition was also in April 2023. Thereafter, two dates were there: 2nd April, 3rd April, and 11th April, and thereafter on 12th April, the judgment has been passed. Now, kindly sees from where this has cropped in. That is what I'm trying to substantiate. My contention would be, kindly comes to page 18. Or kindly straight away comes to page 21.
21 of what?
Of my compilation. This one that I've had.
Yes.
This is a proceedings which arose out of, my lord, an order passed by the honorable single judge in Ramesh Mullik and Somen Nandi matter on 13th April 2023. Lordship has found 13th April, and my lord, Somen Nandi is WPA 9979 of 2022, which was been analogously been heard by the honorable trial judge, and our matters were also being heard. And these orders have been pointed out to your lordship by the honorable by Mr. Shin. Now, kindly cease. Pursuant to the order, page 23. The other orders are also there. I'm just drawing your lordship's kind attention to this one. Pursuant to the order of the court dated such and such, registrar has placed an affidavit dated such and such filed by the Registrar General of High Court at Calcutta. Paragraph 5 of the affidavit of Registrar General states thus: it is stated that on such and such, about such and such, Lordship has been pleased to forward a note prepared by the Lordship in respect of annexures of transcript versions of interview in such and such, an honorable direction such and such. I'm consciously not placing the entire thing. We have considered the note prepared by honorable judge in respect of annexure P7 and have also perused the transcript of such and such. Transcript has been authenticated on such and such. Having considered the transcript, we direct that the acting Chief Justice of the High Court shall reassign the pending proceedings in case to some other judge of such and such. The judge to whom the proceedings are reassigned by the acting Chief Justice would be at liberty to take up all applications and may move them. So therefore, at this stage, when these matters were being heard, the first two matters where the allegations of scam are there were reassigned. And my lord, the only logical explanation of referring to the scam in these impugned proceedings would be the scam which was there and which was alleged scam which was there and was being adjudicated by the honorable trial judge in the month of April 2023 in Ramesh Mulik and Shomen Nundi matter, which were reassigned. And after this order, on two occasions the matter was heard. This Priyanka Noshkar matter was heard. After this order, on two occasions, the Priyanka Noshkar matter was heard. This direction was passed by the Honorable Supreme Court on 28, and thereafter on 2nd, 3rd, and 11th May, the Priyanka Noshkar matter, which the Lordship is hearing now, was heard before the Honorable Trial Judge, and the order was passed. So therefore, the reference in paragraph.
Now, what happened to Shomen Nundi and
These are pending. And
these are not before us?
No. Those are not before your Lordship. Mr. Shakko Sen on the last occasion had drawn your Lordship's kind attention to the orders by which those two writ petitions have also now been stayed by the Honorable Supreme Court.
Yes.
That is 15 July 2024 order.
Where is that here?
It is not there. It is there in Mr. Shakko Sen's my lord. Kindly Kona Shelai korata ektukhani din.
15 July.
Yes. From the last Lordship may takes up 1, 2, 3 pages. 3 pages from the last. 88, I think, page. Page 8. Yes, yes.
Yes. So those proceedings have been stayed.
Yes. Now, my lord, third submission.
SLP is still pending.
SLP, yes, might be pending. I don't have the current status, but it's pending. That is my instructions.
Yes, anything else?
Yes. Next is, Lordship may remember, with now, my lord, not on the merits, on the procedural part. Now, Lordship may remember, during the course of this appeal, I wanted to draw your Lordship's kind attention to the connected applications which have been filed in these proceedings before your Lordship. Lordship had been pleased to, my lord, laboriously go through 72 applications. Lordship it has fallen from your Lordship. Now the number of applications have now increased to 110. I think as of day before yesterday, I have been informed.
No one has addressed us on the applications.
My contention before your Lordship is that only 5 applications have been, 5 or how many applications? They are just 8 applications have been allowed, out of which the stand of the applicants in those applications, some of the applications are that they are supporting us. I'll show that. Only that can be. Now, kindly comes to page 31.
So they are wanting implement vis-a-vis the appellants.
The Supreme Court says that only the persons who are assailing the order.
Show us that.
Yes, kindly comes to, I'll just maintain the sequence. Kindly takes page 31. This is the first order. I am only drawing your lordship's kind attention to show the date of the order. 19th May 2023.
Allowed.
Yes. 19th May 2000.
They allowed, they have
Two
been,
applications. Two applications allowed on that day, subject to maintainability.
They claim to be similar to Priyanka or
Priyanka. Priyanka. Kindly see page 831.
Yes.
Kindly seize the date and the applications.
May.
Yes.
Yes.
This is the first order which was passed by the Honorable Justice, page 31.
Yes.
Yes.
Where is that addition?
Yes. May I just? There were can 2 and can 3 in the board's appeal. Page 31, lordship sees.
Yes.
Can 2 and can 3 were the addition of party applications.
But by those similarly who wanted to join as writ petitioners.
Might be. No applications as of today has been served upon us, board may say.
They claim themselves to be similarly situated with Priyanka or
Priyanka.
Yes.
Now, my lord, kindly sees, may I just draw your lordship's kind attention to the appearances in the application, or my lord, I'll just straight away come to the ordering part. Appearances are at page 32 and 33. Kindly sees at page 32 bottom is for applicants in can 3 of 2023 in MAT 873
and can 2.
and can 2.
Yes.
Now, kindly comes to page 53, which is the internal page 23 of the order.
Yes.
Third last paragraph from the bottom. Application filed for addition of parties stand allowed subject to proof of maintainability. Now, my lord, this particular order was assailed before the Honorable Supreme Court. Next page. Page 54 onwards. And this is the order by which the entire thing has been remanded to your lordship. Now kindly sees what the yes, yes.
Yes. Now against this appeal was prepared.
Yes. Now kindly sees what the Supreme Court has observed in the last paragraph, second last, page 62 of my compilation. Yes.
Yes.
As the controversy relates to selection and appointment of the large number of assistant teachers, therefore we request the High Court to decide MAT 890. This is Tuhin Haldar, where Mr. Kullan Bandyopadhyay was appearing. MAT 874. This is Nolin Kumar Jha. MAT 873 is the board's appeal. And again, MAT 890 has been mentioned, though it has been mentioned previously, or any other case, if any, filed by the aggrieved person assailing the order of the learned single judge as expeditious as possible. So, any other case who are assailing the order. So, that was the order of Supreme Court. In view of this, thereafter, next page kindly sees, another sets of applications were allowed in these proceedings by an order dated 4th September 2023. Two sets of applications were allowed.
Yeah, just.
Yes. Four, 5, 6, 7, 8.
Yes. Now in page 63.
Is the order passed in this appeal by the Honorable Justice Somen Sen, presided, division bench presided over by the Honorable Justice Somen Sen.
Which was before Justice Talukdar first.
Yes. Before Justice Talukdar first.
Now in this page 63, what has been done?
Now, kindly comes to the page 65. These are the connected applications. Can 4
Yes.
Can 4, 5, 6, 7, 8. Lordship has seen can 4, 5. Next page are the appearances. Lordship has seen, my lord. Next page, the appearances. Can 6, 8, 4.
What you are
Now, kindly see what I'm trying to show. Kindly comes to page 79. The paragraph 72. Lordship is there in page 79.
Yes.
Kindly see the orders passed here. Can 3, 4, 5, 6, 7. 4, 3, 4, 5, 6, 7. These are applications for addition of party.
No, but can 3 was not there at page 65.
This is in respect of MAT 890. That is in respect of the board's appeal. MAT 873. There were two sets of applications.
So these were in connection with
Tuhin in Mr. Kullan Bandyopadhyay's matter.
This can 1 and 2 in 890. Yes.
Yes. These are applications for addition of party.
Similar to Priyanka.
They say so. The learned counsel for the applicants submits that they stand on the same footing as that of Priyanka Noskar and others. Page 80.
Page 80, you are showing can 6 and 7.
No, it is from previous page 79 onwards. It is showing.
Yes.
Continuation.
Yes.
Paragraph 62, 63. The learned counsel for the applicant submits that they stand on the same footing as that of Priyanka Noskar and others, under whose favor the judgment was passed by the learned single judge. We allow only one representation from the applicants to be made at the time of hearing. we only permit one counsel to argue on their behalf on the basis of the available records and not on any fresh materials. This is one set in respect of Tuhin. Now kindly comes to the next set, page 81, in respect of the appearances that I have drawn your lordship's kind attention to.
Yes.
Can 4, 5, 6, 7, 8 in MAT 873. Lordship has.
Same thing, we allow one counsel.
Yes.
What you are trying to say?
They had mentioned these matters again. Now kindly comes to page 89. This is the order of 26 September 2023. This matter appeared as item number 4 in the list. I am carrying the list. If your lordship wants, I can show. Page 84, lordship is there.
Yes, page 84. This is on 26 September 2023.
Page 88 are the appearances. In item number 4, kindly sees item number 4.
Sir, what you are trying
Kindly sees what they have made the submission. This matter, 89. This matter has come at the instance of the applicants in CAN 44 such and such. In paragraph 77 of the order dated 4th September 2023, it has been inadvertently recorded that the appellants stand on the same footing as that of Priyanka Roshkar and others, under whose favor the judgment was passed by the learned single judge. Factually, they are successful candidates, and by reasons of the impugned order passed by the learned single judge, their services were terminated. So they are virtually supporting us. This bunch of appellants before your lordship, counsels. It was at their instance.
So what you are saying, they cannot appear now. They
No.
cannot appear in this
If
matter.
they can appear, but they would be supporting us. They cannot say anything criticizing our appointments.
Where is this paragraph 77 of 4th September?
It's 95.
Where is the 4th September order?
Yes. It starts from
Page 63.
63. Paragraph 77 is at page 81, 82.
Very good. We shall take note of.
That's. Oh, only one judgment, my lord.
So
It is
you are meaning to say that by virtue of 8 applications were allowed, addition of parties.
Yes, this I have made a list. Only those applications which have been allowed.
Though in the application they said that they are similarly
We
situated.
don't know. None of the applications have been served upon us. As of today, so many applications have been filed. We don't know what are the
So
contents.
nobody has addressed us on the applications.
So therefore, my contention is that we have shown before your lordship
Very
as it
good.
appears on
They
the
are
order.
also then supporting your claim. What you are trying to say? No, that is absurd because they have challenged.
They have said so. These are the applications.
Yes.
Well, I have just made a note of the applications which have been allowed. And applications 2 and 3
chance applicants, they have been added in the cost item.
I don't have any instructions because we are not the main appellants. The main appellants are the board, and if
Office has never been directed to incorporate their names.
I don't think so, they have been added.
Now, only once, Mr. Fiddoswamy, you said that you are in CAN 5.
CAN 5 is mine.
All those applications are addition of party application.
But some of for additional parties, and CAN 9 is for addition of order 41 rule 27 additional documents.
But have your names been incorporated?
No, not yet. Cost title not yet amended as per subject to
Where
correction.
is the order that office should correct the cost?
No, there is no such order.
So we will hear you.
Yes, yes. We just once here.
But
Well,
their
circumstance
contention,
standard petition.
their contention as recorded will be, they will be supporting us.
No, never.
That is the recording. That is the recording. That is the recording. They have not challenged.
No.
These are also in 870.
There is one difficult. One is, it is a voluminous brief, 44 appeals are
We
here.
all are referring to AMAT 870.
So we can, suppose you are arguing, if our judgment is pertaining to the 2016 process, question of formal addition does not arise because it is applicable to all.
Yes, yes. Is this matter just like my lord, APA payment?
Therefore, my lord,
Remember APA payment.
so therefore, my lord, the addition of party applicants, whatever they say, they
If
have
your
to,
contention is in view of that recording, they are in your favor.
and they are bound by that. It is at their instance.
Yes. Anything else?
One judgment, I'll finish. And another point is that maintainability of the applications have to be when they are called up.
When they are called on?
When they are called up to say, because there can 2 and 3, the applications which have been allowed.
No, kindly come to the Supreme Court order.
Yes.
What did the Supreme Court say?
Yes, assailing.
Supreme Court says those who want to assail, they will be hard.
Yes.
That is pertaining to your class of candidates.
And my lord, in view of this, since CAN 2 and 3 was allowed subject to maintainability.
Where is that line?
Page 23.
No, those who are agreed.
Yes, page 23 of my compilation.
Paragraph?
Oh, just a minute. Sorry, my lord. Not page 23. Sorry. Page 62. Page 62.
Page 60.
Page 62. 62.
Is this the last order of the Supreme Court?
Other orders are there, but these are following this one. This is the order pursuant to which everything is being done before that. So in view of this line, CAN 2 and 3 would not be maintained, which has been allowed pursuant to the previous order passed by the Honorable Justice, Division Bench presided over by the Honorable Justice Talukdar. Because CAN 2 and 3 were allowed subject to maintainability. Now, when CAN 2 and 3 is taken up by your lordship, Lordship has to consider the
Be
point.
bound by that statement.
So therefore, anyone who is not supporting us may not. And that set of councils, they are bound by their own.
Just highlighting, you are taking a technical issue. Yes.
We are entitled to take technical issues, my lord.
All right. Thank you.
Now, my lord, 2003-7, one judgment only with regard to segregation I have given. Oh, no.
Here you have annexed. Here you have.
This is different. 7 SCC 285. Here, a selection process conducted by the CBI was in question. 3-7 285. Things out of which this arose. Paragraph 2, the Central Bureau of Investigation for SORT invited applications on 29/3/2000 for filling up such and such. So this arose out of, my lord.
Which para you are referring?
Paragraph 2 is the fact.
Now, what is the proposition?
Point is that.
Para 6.
Point would be paragraph 6, last, that there should not have been in block cancellation. There has to be a segregation.
Where is that?
Placitum D.
Placitum
D. Applying a unilateral, rigid and arbitrary standard to cancel. Applying an unilateral, rigid and arbitrary standard to cancel the entirety of the selection, despite the firm and positive finding that except 31 of such selected candidates, no infirmity could be found. With reference to the others, is nothing but a total disgrace of relevance and allowing to be carried away by the irrelevance, giving a complete go-by to the contextual construction, throwing onto the winds of principles of proportionality in going further than what was strictly and reasonably to meet. In short, the competent authority completely misdirected itself in taking such an extreme and unreasonable decision to cancel the entire selection, wholly unwarranted and unnecessary even on the factual situation found to, and totally in excess of the nature and gravity of what was at the stake, thereby vitiating, rendering such decision to be irrational. These are my submissions that there should be segregation. Deeply obliged.
Please, Shonu.
Is your lordship.
Your part?
I am for the appellants. I am in mat number 1615, serial number 82 in your lordship's daily cause list.
You are a Matt?
1615, lordship. 1615, 1615 of 2023. Saurabh Boshak and others. Lordship, I must admit at the very outset, your lordships have been very kind and exceptionally patient.
This compliment will remain after we deliver the judgment.
I was in two minds whether I should. As your lordship has shown, is a matter of fact. In fact, I did not want to.
Come to your case, yes.
May I just say one thing, because your lordship said it. When I started my profession, Mr. Lordship, in 1615, there are 334 appellants. They're all from the district of Jalpaiguri.
They were appointed and thereafter completed training.
Yes, Lordship. The appointments of all the 32,000 were over by April 2017.
Yes.
These individuals were appointed, post all the trained candidates were appointed.
So this 32,000, this cancellation includes untrained.
Yes, that was
the untrained.
Yes, because the impugned order
Yes.
makes a specific reference saying that in fact, let me just get to
Yes,
that.
yes, paragraph 7. Yes.
It says the trained are exempted. Yes. So
trained are?
the trained were not part of that order. That's about it. Yes.
No, we are asking this 32,000 is trained, untrained persons who
Untrained
participated and got the training.
Absolutely. And they were trained by 31st of March 2019.
Training was over by 31st of
2019. Because I'll just reiterate just two points. Lordship has heard it. After the directive principles on education was called out by Supreme Court and said right to education is a fundamental right, the central legislature came out with the Right of Children to Free and Compulsory Education Act 2009.
Yes, we need not go.
Yes, and so once
What is your
NCT gave the guidelines, then TET started. So therefore, and these are trained, these are untrained at the time of induction, trained by 2019. Now, much has been said about the interview and the aptitude process. There are two things I need to point out, very specific to this case. In this 334 appellants from Jalpaiguri district, now what has come to our notice on perusal of the record, that in the impugned order, what it does not have anybody, no interviewer, no candidate, and none of the 139 petitioners are from the Jalpaiguri district.
No Jalpaiguri person amongst the 4 petitioners who were examined.
The petitioners.
Jalpaiguri district.
Yes, and there are few other districts in the state in which the similar situation is there. No petitioner, no candidate interviewed, no interviewer asked question by the state. And to give a quietus to that issue, Lordship, my senior Mr. Shagor Bandyopadhyay, when he had appeared, he had handed out this one notification, one memo, a notice from the board. I'll just reiterate only one point in this, Lordship. This is dated 5/12/2016. Lordship may go overlive. This is a notice to the districts. Lordship may turn over to the second page. I'll forward.
Yes.
The chairman copy forwarded for information to the chairman interview board and DI of schools of the 4 districts, namely Kuch Bihar, Howrah, Purbo Mednipur, Bardhaman, for making arrangements for smooth conduct of viva voce / interview and aptitude test and scrutiny verification. Now, Lordship, I just stop here for making arrangements for smooth conduct of viva voce, public interview, and aptitude test.
Yes.
The point I'm trying to highlight, Lordship, the board goes on record, sends notice, and informs them for the purpose to the DPSC for purpose of conducting interview and aptitude test.
Yes.
That's the best documentary evidence as a candidate that I can lay my hands on to prove that point. Lordship, I'll have just two basic legal issues, though this looks very heavy. I will just Lordship in this compilations, he's handing over. It has been a tough job on my part to ensure that no repetition takes place. Lordship may come to the judgment in serial number 4, 2009 8 SAC 106. 2009 8 SAC 106. It's a famous case of R.K. Anand versus Registrar, Delhi High Court.
Yes.
Lordship may kindly come to page 120.
Which paragraph?
Para 292.
You will be relying on paras?
292, 293, 328. Then 329, 332. May I start?
Show us the relevant paragraph.
Yes, Lordship. Lordship may kindly come to the page 120 of the compilation. That is internal page number 198.
We are there.
Yes, Lordship, paragraph 292.
Yes.
The submission of Mr. N. Rao are based on two premises. One, the sting of program telecast by NDTV was of the genre trial by media. So that's my point, Lordship. Trial by media. And two, the program interfered or tended to interfere with or obstructed or tended to obstruct the proceedings of the BMW trial that was going on at the time of the telecast. If the two premises are correct, then the rest of the submissions would logically follow. But are the two premises correct? Now, Lordship comes to the para 293 when the court questions what is trial by media. What is trial by media? The expression trial by media is defined to mean the impact of television and newspaper coverage on a person's reputation by creating a widespread perception of guilt, regardless of any verdict in a court of law. During high publicity cases, the media are often accused of provoking an atmosphere of public hysteria, akin to a lynch mob. Akin to a lynch mob, which not only makes a fair trial nearly impossible, but means that regardless of the result of the trial, in public perception, the accused is already held guilty and would not be able to live the rest of the life without intense public scrutiny. I pause for a while, Lordship.
Yes.
In this case, Lordship, with all humility, as I try to understand the rationale behind the impugned order, I'm not passing any judgment on human being. I'm not passing any judgment on any individuals. I'm just trying to assess the judgment within the parameters. Now, what happens is, in this case, Lordship, the 32,000.
Yes.
The 32,000, Lordship, with absolute humility, if I may say, that in the investigation by the Central Investigative Authorities, CBI and the ED,
all right, we understand you.
No, but my point is not a single one has been accused. Yes. Now, Lordship may kindly come to page para 328, 329. That is 328 is at page 126 of the compilation, Lordship. We also find that, like almost every other sphere of human activity in the country, the electronic paragraph 328, we also find that like almost every other sphere of human activity in the country, the electronic news media has a very broad spectrum ranging from very good to unspeakably bad. The better news channel in the country, NDTV being one of them, are second to none in the world in matters of coverage of news, impartiality and objectivity in reporting, reach to the audience and capacity to influence public opinion, and are actually better than many foreign TV channels. But that is not to say that they are totally free from biases and prejudices, or they do not commit mistakes or gaffes, or they sometimes do not tend to trivialize highly serious issues, or that there is nothing wanting in their social content and orientation, or that they maintain the same standards in all their programs. In the quest of excellence, they have still a long way to go. And the next paragraph is what I'm little perturbed with, and it reflects what happens. A private TV channel, which is also a vast business venture, has the inherent dilemma to reconcile its business interest with the higher standards of professionalism demands of profession. The two may not always converge, and then the TV channels would find its professional options getting limited as a result of conflict of priorities. The media trips mostly on TRPs, television rating points, when commercial considerations assume dominance over higher standards of professionalism.
Yes.
Page.
Anything else?
Yeah, in this, just one more paragraph, Lordship. I'll just read page 127 in the compilation, paragraph 332.
Yes.
I'll just read the first sentence and leave it at that. No personal aspersions, but this is something which perhaps Supreme Court also said, don't do it. We have viewed with disbelief senior advocates freely taking part in TV debates or giving interviews, or a TV reporter, anchor of the show on issues that are directly the subject matter of cases pending before the court, and in which they are appearing for one side or taking up briefs for one of these sides soon after the TV show. Such conduct reminds us of.
But there is no such allegation here.
No, I'm not. I'm just saying what in the parameters of trial by media. Lordship may kindly come to the first judgment in my compilation. First judgment in my compilation, 2023, page 1, Lordship, of the compilation.
Yes.
2023, 9 ACC.
Paragraphs?
Yes, I'll just, paragraph 6, page 186.
Para 6.
Para 6, Lordship. 186, para 6. I'll skip para 6, Lordship. I'll read it out. Media reporting on matters involving commission of crime.
Relevant.
Lordship may kindly come to paragraph 7.
Yes.
Paragraph 7, it starts at page 120. If your Lordship may kindly come to the next page, page number 4. In a matter which implicates the culpability of the person who is under investigation. I'm cutting it short. Media reportage in manner in a manner which implicates the culpability of the person who is under investigation is liable to seriously impinge upon the reputation and personal dignity of the individual under investigation. Biased reporting also gives rise to public suspicion that the person under investigation has committed the offense, though the complicity of the accused is yet to be investigated. And
paragraph?
Para 7, Lordship. My apologies. Para 7 starts at page 3.
Yes,
The last two words in that page is media reportage. Lordship may kindly come to page 4 of the compilation. Media reportage in a manner which implicates the culpability of the person who is under investigation is liable to seriously impinge upon the reputation and personal dignity of the individual under investigation. Biased reporting also gives rise to public suspicion that the person under investigation has committed the offense, though the complicity of the accused is yet to be investigated.
Yes.
And in charge sheet is submitted. Lordship may kindly come directly to the last paragraph that I would like to, paragraph 19 in internal page 7, compilation page 7.
Yes.
This is what the Supreme Court, this is 3-judge bench. It deals it like a PIL. It says it is equally important to emphasize the nature of disclosure which is made by the police in the course of media briefing should be objective in nature and should not consist of a subjective opinion prejudging the guilt of the accused. The guidelines must duly factor in. This is what I'm insisting on, Lordship. The guidelines must duly factor in the need to ensure that the disclosure does not result in a media trial so as to allow for prejudging of the guilt of the accused. Most important, Lordship, what I'm saying now, media trials are liable to result in a derailment of justice by impacting upon the evidence which would be adduced and its assessment by the adjudicating authorities. So the Supreme Court in this judgment recognizes the ill effects of prejudging an issue by the media.
Yes.
Lordship, I would now go to my next point. Lordship may kindly come straight to the judgment in serial number 7 of my compilation. It's 2025 SCC Online, Supreme Court 179. 2025 SCC Online, Supreme Court 179. Lordship may kindly come to page 160 of the compilation.
Give us the paragraph.
Yes, Lordship, I will. The paragraphs that I would be relying upon is 3, 13, 16, and 68, importantly. 3,
yes,
13. Now, this is a case, the point that I'm...
Yes.
Yes, Lordship, may just permit me just a minute to just go to my compilation. Yes. In paragraph 3, Lordship, in the middle, therefore in the case, Lordship has that. Therefore in the case, we are confronted with a conflict between the two foundational principles of natural justice. That is, rule against bias, nemo judex in causa sua, and the right to a fair hearing, audi altrum partem.
Yes.
Yes. Lordship,
this is
just
on the principles of natural justice. This
does
not give anything new concept.
I understand. There are two parts to it. One is you give a right to hearing and bias. So therefore, the issues are, Lordship, at paragraph number 13.
Yes.
Page 163. Whether the selection is vitiated for violation of the first limb of natural justice, rule against, and that is rule against bias. Lordship has that? Yes. The issue B, I'll go straight to the conclusion after the issues. where it is a case of violation of principles of audio alterum partem, is demonstration of prejudice necessary to succeed with the claim of violation of principles of audio alterum partem, and C, whether the breach of principles of audio alterum partem at the original stage can be cured. Very important, Lordship. At 164, issue number C, whether breach of principles of audio alterum partem at the original stage can be cured at the revisional stage. Lordship may now come to the conclusion. Paragraph number 68, Lordship.
This settled proposition, it cannot be cured.
Yes, that's about it. And it says so.
Settled proposition. Yes. Thank you, Mr. Majumdar. Yes, anybody else?
Lordship, may I just take half a moment?
Yes.
There's a Delhi High Court judge.
Another judgment you want to show?
No. I just want to say something. On a lighter side, I'll just take half a minute. In his retiral speech, Lordship, he said there's something very important. He said, when a petitioner comes to the court on a trial, the petitioner knows what is right, what is wrong, the facts. The respondent knows what's the fact. If anything is on trial, is the judges. So, Lordship, as I leave you with the onerous task, I am most deeply grateful and obliged.
Thank you. Yes. Yes, Mr. Banerjee.
The last man standing, Milord. Milord, I'll try to be as precise as possible.
Some more after you. Some more after you. Not the last.
No. After me, Milord, there is.
Take a look.
Pardon?
Milord, I thought, Milord, I'll be having the.
No next day, Mr. Chakraborty. We are finishing the petitioner's argument today.
Milord,
Yes, get yourself ready, Mr. Yes.
Yes, Milord. Kindly, Milord, allow me, Milord, to.
You are for which appellant?
Milord, I am appearing, Milord, in item number 64 and 97. 97, Milord, all the appellants are para-teachers.
Item number
64 and Milord 97.
So you have been briefed by both the branches?
No. Milord, I am briefed, Milord, by para-teachers and Milord, some of the appellants, Milord, who are selling in the same boat like my Milord, learned senior friends clients.
Fronts you have been engaged?
Yes. Para-teachers and non-para-teachers, Milord, if I may classify in that way.
64, how many appellants?
64, Milord, there are, Milord, 165 appellants. And 97, there are, Milord, 283 appellants.
All your para-teachers are TET qualified?
Yes. Milord, item number 97, all are para-teachers.
Anybody TET 2012 qualified?
No. TET
All
24.
TET.
Yes.
Yes.
Now, Milord, kindly allow me, Milord, to hand up, Milord, two, Milord, compilations.
68.
Possibly, Milord, I am offering the, Milord, thinnest compilation, Milord, in this matter.
No.
Milord, para-teachers, Milord. Para-teachers, Milord, make a different class altogether. Because
that has been argued.
Yes.
Mr.
Milord, I'll just, Milord, try to be precise. Milord, I'll not repeat. Milord, this is a horizontal reservation. 10% of, Milord, the total number of, Milord, vacancies. Milord, I just indicate what was, Milord, the total number of vacancies and, Milord, what should have been, Milord, the number of vacancies available for para-teachers. 42,949 was the vacancies. So, Milord, 42949. So, Milord, 10% of that will come to 4294. And, Milord, number of para-teachers, Milord, who were 4294 will be 10% of 42949.
4294.
Yes. Milord, you just shift, Milord, one decimal towards the left hand side. So, Milord, it's 4294.
That's approximately 43.
Yes.
No, no.
4,300 approximately, Milord, 4,300 if you will round it off.
Right, right.
Now, number of para teachers who were actually appointed, Milord, is 2770.
Two, seven,
70.
That
So,
is
Milord,
exceeding the 10%.
no, much below 10%. 4,294 was Milord 10%. 4,294 was 10%. And 2,700 only Milord were appointed. So it's a much below Milord. It's almost Milord half. So even Milord, had I got Milord 0 Milord in the recruitment test,
yes,
Milord, I had a right to be appointed. Because
If you
Milord,
got a-
those,
Even if you got a
even if I got 0, had I got 0. That's Milord the rule says, that's what the law says, that's what the recruitment notification says, that's what Milord the amended notification says. Because Milord, this is earmarked. Now Milord, I can't get 0 because Milord, there are academic marks for academic scores and
never
all.
get 0.
Yes.
Your academic is there. Your
Yes,
training
everything is there. Milord, I am putting my case, Milord, to the worst possible level and to trying to argue that, Milord, for me, Milord, there is no contender. For us, there is no contender. Nobody can, Milord, allege that, Milord, is because of our appointment, somebody has been deprived. Because, Milord, the reserve vacancies could not even be filled up. And these were earmarked for us.
It is not a question of no contender. It is a question of fraud scam in the selection process.
Milord, so far as para teachers are concerned, Milord, there is no allegation of fraud and scam. I tell your lordship, Milord, why?
That allegation is also not there in respect of others.
Milord, so far as para teachers are concerned, Milord, these allegations have got nothing to do. Milord, I tell your lordship, Milord, why? Milord, the way the Honorable Single Judge, Milord, has called out, Milord, trained candidates saying that, Milord, they constitute a different category altogether. I do not touch it. Though, Milord, according to the Honorable Single Judge, Milord, there are scams, there are etc., etc. So many things are there.
Where is I do not touch it? Where did you find that?
Milord, that is there in the impugned judgment. Milord, before I take your lordships to that, may I show, Milord, the rules, Milord, that deal with para teachers. Kindly, Milord, have a look at, Milord, the rules, Milord, at page 6 of the compilation. Kindly turn to Milord 6, it starts. Kindly turn to page 9.
Where you are reading?
Milord, from the compilation. Milord, need not take any other document, Milord, as of now. Only the compilation, Milord, which I just now handed over. Kindly, Milord, have a look at page 9.
Yes.
Milord, note 7 towards the middle of page 9. The state government may by notification in the official gazette, note 7, Milord, somewhere towards the Milord middle, slightly Milord down below. Earmark up to 10% of the total posts for candidates belonging to para teachers without disturbing 100-point roster as not.
No aptitude test.
I have Milord teaching experience marks. Teaching marks Milord for teaching experience, which substitute Milord aptitude test.
That is note 8.
Yes, Milord, in the subsequent notification.
No, no, not so 8.
Milord, I'll take your
Rule
lordship
8,
to that.
Note 5.
Yes, correct.
You have 5 marks for.
Milord, instead of having this marks, Milord, for aptitude test, Milord, I have to be, Milord, marked, I have to be assessed, Milord, on the basis of my teaching experience. So whether or not there was an aptitude test, Milord, that hardly, Milord, matters so far as we are concerned. Kindly, Milord, take page 11. I'll quickly, Milord, take your lordship, Milord, through
Yes, we are on page 11.
11. Milord, clause 5, subclause A. Kindly see, Milord, the mandate of the rule. It says you first segregate the para teachers. Clause A starts with, Milord, firstly, selection committee shall segregate. Then comes, Milord, the consideration of the other candidates. Secondly. So, Milord, we form a different class altogether, class apart.
Yes.
Then, Milord, kindly turn to, Milord, page 15.
15.
15. I'm sorry, Milord, page 16. 15, Milord, the notification starts. 16. This is, Milord, subsequent.
The amendment.
Yes, the amendment. And my lords were, Milord, referring to rule 8. Here comes, Milord, rule 8. 16 towards the middle.
Aptitude deleted, teaching experience.
Yes. And, Milord, this or is disjuncting two parts of the sentence, Milord, not two words only. Well, that's nobody's case that, Milord, for para-teacher, there has to be an aptitude test. Can't be anybody's case.
Where is that or your?
Milord, that or, my lords, will get, Milord, 4A, third line. Viva voce or interview and aptitude test, or then, Milord, a disjunctive clause status, Milord, the separate clause, teaching experience in case of para-teacher. So, Milord, this or, Milord, disjuncts the first portion of the sentence from the second portion of the sentence.
Yes.
Now, kindly, Milord, turn to the recruitment notification once. Kindly take, Milord, page 18. Milord, a further notification came on the same day. Notification number 657. 6, Milord, page 18, 1/8, Milord, of the compilation. First recital again deals with, Milord, reservation.
This is the same notification.
No.
Same date.
Same date, different notification. Numbers would not tally, Milord. Different notification. On the same date, two notifications were there.
Yes.
Kindly take, Milord, the first recital clause, Milord, first. It says, third line, earmark up to 10% of vacant posts for para-teachers without disturbing the roster. Second recital, rather, Milord, the habendum, if I may call it. Governor is pleased to hereby direct that during forthcoming, etc., 10% of existing vacant posts shall be filled up by the para-teachers. So, Milord, this is reserved for us.
How does that improve your case?
That improves my case, Milord, I tell your lordship. Milord, now, Milord, there is an allegation that, Milord, there was no aptitude test.
That you have
That,
argued.
Milord, does not touch upon me.
Very good.
Milord, there is an allegation that, Milord, selection committee was not constituted. Milord, that is one of the foundation, Milord, if I have understood correctly, Milord, of the impugned judgment.
But in their case also there is a selection committee.
Milord, I will show, Milord, what was the duty of the selection committee and how could, Milord, the Honorable Singh.
Okay, but that does not distinguish you.
That does not,
Matter.
that's not a distinguishing feature.
Yes.
Distinguishing feature, Milord, is this.
Aptitude teaching.
Yes.
Yes.
Yes. And, Milord, reservation.
Was that line?
And
which you
reservation.
just now
Yes,
said?
Milord, the
What did you say that line was?
Yes. Yeah, markta করেছিস? আচ্ছা।
Not touching the para-teacher.
Kindly, Milord, take. But kindly allow me, Milord, a moment's time.
Ask your junior to find out. You proceed.
This is in paragraph 5,
Paragraph 5.
8613.
এখানে আমার কি আছে? Para?
Paragraph 5 of the impugned judgment. Internal page 3, Milord.
Yes.
Paragraph 5. Milord, the opening paragraph. One of the opening paragraphs. During course of hearing, petitioners disclose various particulars in the website, etc., when viewed in respect of untrained candidates at the time of recruitment, and while disclosing such particulars, they made it clear that all their allegations of illegalities in recruitment are in respect of untrained candidates at the time of recruitment who were given appointment in 2060 recruitment process. And at the same time, it was made clear that they do not have any grievance in respect of the trained candidates who were trained at the time of the recruitment and were given appointment in 2016. And the Honorable Single Judge accepts that.
No, where is that exclusion of para?
Then, Milord, the sentence that starts with therefore. Therefore, the candidates who were trained at the time of recruitment are outside the scope of this matter.
Where is para teacher outside?
Milord, my submission was the way, Milord, trained were excluded.
That is
If
your
they form, Milord, a different category.
Entered a line which we didn't get in the order.
Milord, that's the line which says that, Milord, traineds are not being.
They are not being touched. You said that.
Trained are not being touched, my lord. That's
No,
what,
no,
my lord.
para teachers are
No,
not.
no, my lord. My submission was the Honorable Single Judge said trained are not being touched. If, my lord, on the, my lord, justification, on the reasoning, on the logic that, my lord, trained form a separate class, there is no allegation. My lord, if that be so, then, my lord, against para teachers also there is no allegation. Para teachers, my lord, also constitute a different class.
No, no, you para teachers are also have to undergo training. TET 2014, they have to appear. So
My lord,
that does not exclude them on the basis of these three sentences.
my lord, this TET 2014 is for all.
Exactly. You
So,
are
my lord,
saying
if
that when
today,
you mention trade, we need to construe that para teacher is not within the ambit of this. This, sorry, we do not find.
the para
Line is not there. That para teachers are not, we are not touching the para teachers.
No, my lord, my submission was, my lord, I'm sorry, my lord, I could not, my lord, clarify myself. My lord, the line was that, my lord, the trained are not being touched.
You are also trained. Para teachers are also have.
Now, my lord, we are all trained and within the time, my lord, stipulated by, my lord, the last notification. Now, all of us are, my lord, trained. My lord, we are no more, my lord, para teachers. Now, my lord, we are trained teachers.
You were untrained at the time of selection.
Correct.
So that is why they are saying at that juncture, court says trained are outside this. That will suggest the trained persons who are not the untrained candidates. Untrained includes primary teachers as well as para teachers.
My lord, I was trying to, my lord, fathom, my lord, the logic. My lord, if today the selection process, my lord, as a whole, my lord, as my lord, they were trying to allege, my lord, is bad in law. Then, my lord, how, my lord, a group of persons, my lord, can be segregated, can be, my lord, kept untouched. My lord, if selection committee, if the allegation is that the selection committee has not been constituted.
Your next point.
Yes,
What is your next point?
Now, my lord, on the point of, my lord, delay and latches. That, my lord, they are all untrained. None of them is trained. So, my lord, they are not assailing, my lord, trained candidates. Likewise,
There
my
are
lord,
no para teacher.
no, there was no para teacher, my lord, as a
Say
petitioner.
that. Yes.
So, my lord, they could not have had, my lord, any sort of allegation against appointment of para teachers first. My lord, on, my lord, this delay latches, my lord, I just add one point. My lord, I'm sure, my lord, that has been argued also. I say it's not, my lord, only about the delay. My lord, the moment, at the material point of time when the writ petition was filed, my lord, they had seized their right even to be considered for appointment.
This has been argued. Sir.
True. And, my lord, the judgment, my lord, of the Honorable Division, my lord, Supreme Court.
2 years training completed 2009.
Correct.
That is your.
And, my lord, 2022, they came up with the writ petition. So, by the time they had lost their right. So, my lord, here there were some petitioners, my lord, who were nobody. Could not have, my lord, even raised any grievance. Could not have had, my lord, any locus, my lord, to even raise an allegation. And this was not by of a public interest litigation. This was an adversarial litigation for establishment of their purported right.
Yes.
Now, my lord, from Honorable Justice Mitra, my lord, a query failed, my lord, if I could understand that correctly, my lord, even if I, my lord, why did I say that, my lord, even had I got 0, my lord, I could have been, my lord, appointed because there was no cut-off mark, my lord, for the para teachers. So, irrespective of, my lord, whatever I get.
No cut-off for anybody. No cut-off for anybody.
For the para teachers, my lord, there is no cut-off mark.
No, for the untrained also no cut-off.
No. I mean, that was the reason, my lord, why I submitted this. My lord, there was a number of vacancies available for us. The total number of us was much less than the number of vacancies available. So, my lord, our appointment was otherwise automatic. Now,
you cannot say automatic. You cannot say just because there are vacancies, I will include incompetent person who got 0. That is the discretion of this.
my lord, my competency was, my lord, decided by the my lord, assessed by the selection committee. My lord, I'll take now your lordship, my lord, to that particular rule. Kindly, my lord, have a look at Rule 7. My lords will kindly get, my lord, Rule 7 at, my lord, page 9 of the compilation. Rule 7, my lord, deals with selection committee.
Rule 7.
7, Millard, at page 9, bottom.
Yes.
Millard, kindly take Millard Rule 8. Rule 7 says, Millard, how a selection committee is to be constituted. Then Millard kindly comes to Millard Rule 8 that deals with Millard the function of the selection committee. Kindly see Millard the restricted function, limited function of the selection committee at Millard subclause 2, subrule 2 of Rule 8. The selection committee shall call all qualified candidates as mentioned in subrule 1 for the viva voce or interview and aptitude test. And Millard subrule 1 says selection committee shall make prima facie scrutiny of the duly filled in application forms submitted by the candidates having qualification as mentioned in Rule 6. So Millard, what the selection committee was supposed to do is Millard to see whether Millard we have produced all the testimonials and Millard whether we Millard have the qualification. Now Millard qualification means Millard DLED, and Millard for those who do not have it, after Millard all the trained candidates are Millard appointed, rest of the Millard vacancies should be filled by the untrained candidates, subject to the condition that within a particular time Millard will get Millard the qualification. Now here selection committee's Millard role was limited to the extent of Millard this scrutinization of Millard scrutiny of testimonials.
Yes.
The Honorable Single Judge came to the conclusion that selection committee was not there. So Millard, that was something which was not in accordance with the rule. But having Millard decided that, having observed that, Millard, the Honorable Single Judge said, let us Millard again Millard do the interview and aptitude test Millard de novo. Millard, this aptitude test and Millard interview are Millard of those candidates who have been
In the order.
Yes, there are directions.
That
Millard,
there was no selection committee.
There is Millard. There is Millard a finding.
Paragraph 16.
Yes, Millard, I'm grateful to your lordship. Now, Millard, if there was no selection committee, Millard, the automatic inference Millard ought to have been then that Millard the testimonials are again to be scrutinized. Then Millard the testimonials of the trained Millard are also to be scrutinized. They cannot be left Millard untouched. Millard, the interview, viva voce, aptitude test, those are Millard the duties of the interview board. So on one hand, Millard, the Honorable Single Judge is saying there was no selection committee. Then Millard, he is leaving Millard the trained candidates aside, saying that Millard testimonials verification is fine. Let us start with aptitude test and Millard viva voce or interview. So Millard, these are Millard, in my most humble submission, Millard are conflicting, Millard, contradictory Millard observations. Cannot Millard parallelly run, cannot run together. Then Millard, subrule 2 of Rule 8, it says performance of the candidates who will be called for viva voce or interview and aptitude test shall be assessed separately by the interview board. That is exactly what has been done. And Millard, subrule 8 also suggests, subrule 8, Millard, Rule 8, subrule 2 at page 10 of the compilation.
Yes.
Millard, it says this aptitude test, viva voce, interview, all these are to be done, Millard, by the interview board. And if my lord looks at the construction, the language in which subrule 2 is couched, it also indicates that my lord aptitude test and interview will happen, my lord will take place simultaneously together. Kindly see, my lord, the language in which subrule 2 is couched.
That is exactly that is done. Interview.
And my lord, the Honorable Single Judge, my lord, was of the opinion that my lord no aptitude test took place. My lord, I'll show from the notices, the notifications.
Lord, argument subject to correction. Paragraph court holds that there was no selection committee.
Correct.
If there is no selection committee, you are sending it back to the same selection committee. Paragraph 23.
Correct. And my lord, you are sending it back at a stage. You are sending it back to a stage when the duty of the selection committee was over.
That may not be there because
Yes,
court has
it seems to be so.
no.
It clearly appears rather to be so. The Honorable Single Judge has not directed re-verification of the testimonials, which was the duty of the selection committee. So if selection committee was not there, then who verified? And that was never the allegation that the verification was wrong. So remember Isaac, I'm sorry. Rule 2 says that this will happen, aptitude test and interview will happen simultaneously by the same board. At the same time, by the same board, by the same group of people. And that was the requirement of law.
Yes.
Then kindly take the notifications that by which or the notices by which the candidates were called on for viva voce and aptitude test. Kindly take one sample notice. Page ta bolto. Page 43. Kindly take page 43 of the compilation. This was the notification. Evidence sector to mark. Now kindly see the notification with the language of the notification. Second line. The recruitment process is in full swing for conducting scrutiny, verification of the testimonials and viva voce interview and aptitude test. Qualified candidates, those who have submitted online application, etc. are hereby called upon. The time, venues for scrutiny of the documents and viva voce and aptitude test of a particular district or council would be notified in the website. So, these group of petitioners, writ petitioners, they knew the rule. They knew that this is to be held simultaneously, and this is being held simultaneously. Then they made a hue and cry that there was no aptitude test.
Yes.
If kindly turn over the page, the next document, at page 44 of the compilation, this was shown to your lordships. Is individual call letter. Says the same thing that a candidate is being called on not only for viva voce but also for aptitude test. Strictly in adherence to the requirement of Rule 8. Well, single judge relied on the testimony, if I may at all call them testimony of 4 witnesses, 4 persons. Let us not call them witnesses. 4 persons who were from 4 districts: Hooghly, Uttar Dinajpur, Cooch Behar, Murshidabad, which are referred to in the impugned judgment.
7 petitioners were examined.
They are not petitioners. They were members of the interview board.
No. The candidates.
Correct.
7 candidates were called. And how many interviewers?
4.
Eh?
3 interviewers, 26 petitioner candidates. 7
No.
plus 19.
Interview was taken of how many interviewers? By the not say interviewers, but how many the judge examined how many interviewers?
30 number of interviewers.
There is a chart. There is a chart given. Yes, there is a chart given.
But they were not from all the respective districts.
Not from all the respective districts.
5 districts.
Uh-huh.
Names were given by the board.
And Millard selectively they are chosen. Now, Millard, kindly have a look at Millard. The Honorable Single Judge was of the view that Millard, this is an exercise under section 165. Kindly, Millard, have a look at the language of 165. Millard, 165 says parties. Millard, kindly just keep this in mind. Millard, I'm not troubling by reading it out. Kindly, Millard, have a look at this.
Evidence at
It says, Millard, parties and witnesses of parties. Millard, I being a judge, Millard, with Millard, the deepest of respect, possibly I don't have Millard the jurisdiction, Millard, to choose a person who is to be examined as a witness. Millard, if I as a party, Millard, choose one witness, the Honorable Judge, Millard, can examine him under section 165, but cannot, Millard, possibly choose someone to be a witness when not called upon by a party to the litigation.
Where is the bar in 165?
Millard, kindly have a look at the language. And Millard, I am Millard fortified by 1 or 2 decisions. Millard, I'll just indicate Millard the citations. The judge may Millard hand up on. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of the parties about any fact relevant or irrelevant and may order, etc., etc. But these persons were neither parties nor witnesses produced by parties. Millard, who can be called upon as a witness is not possibly, Millard, within the domain of section 165. And then kindly take the second proviso, last line.
Now, where do we get that?
Millard, let us, Millard, read once more, Millard.
Yes.
The judge may,
Yes.
in order to discover or to obtain proper proof of relevant facts. Millard, I am not on the relevancy of facts. My learned senior friends, Millard, have argued that. Ask any question he pleases in any form, at any time, of number 1, any witness, number 2, or of the parties.
No, witness is the general term. There it is not that the witnesses brought by the party. It is not like that.
Millard, possibly, Millard, that is the only possible interpretation.
But
Yes,
that does
yes.
not shut away to judges. This is where the judge, the argument has been the judge cannot act as the prosecutor. That
Cannot,
effect they
Millard.
have.
Yes.
Yes.
Now, kindly have a look at Millard's second proviso. Millard, the last sentence. Or Millard, the last part, rather the last part of the last sentence.
Yes.
Nor shall he dispense with primary evidence of any document, except in the cases herein before excepted, Millard, those deal with sections 121, 131, 148, 149, those have no manner of application here. So, Millard, primary evidence, documentary evidence always has primacy. Millard, the Honorable Judge or the learned judge calls upon someone, Millard, puts, Millard, 2, 3 selective questions, then asks him, Millard, to get down. And, Millard, that testimony cannot prevail over, Millard, what surfaces from the documents. Millard, here there were documents to show that, Millard, aptitude test had been held and, Millard, marks were given. So, Millard, this primacy of documentary evidence
Aptitude test was held.
Millard, the call letters,
Millard, the invitation to
Millard, the
judge.
mark sheets, Millard, given, Millard, by the, Millard, interview boards,
Where do we
showing
get
that, Millard, those documents have already been shown to your lordship.
No,
Yes,
it wasn't shown.
Millard, those have already been shown, Millard. That's why, Millard, I am not repeating.
Maybe we have missed. Dekhi wait karo.
those are primary documents.
Wait. Which one, Mr.
দাদা ওটা
Dev?
কোথায় আছে একবার বলো তো
Affidavit used by, on behalf of the writ petitioner, there is a Shoykot Chalis, the name is, yes, for that.
This one?
Yes.
This one?
Lordship will see the tabulation of marks.
এটা দেখো বের করে দি প্লিজ show it.
It starts from my lord.
Got it.
my learned senior friend knows this matter like the back of his palm.
The headings. Aptitude marks before that, 1, 2, 3, 4 from the right hand side. Aptitude.
No, that is the marks given.
Marks awarded.
Mr. Banerjee was arguing that there are materials on record to show that aptitude test was held by 3 interviewers like that.
Yes.
Marks
Milord,
were given. These we have seen. Marks were given.
So,
your
marks
argument,
given,
marks has been given.
that
There must
lead
have
us
been
to
an
an irresistible conclusion that the test was held. Here is someone who has come.
Banerjee, somebody else may put in the marks. Who knows?
Then we'll be taking our case too high on presumptions.
You think it is a low case? It is interfering.
This is then this is an unfounded presumption. There is no foundational basis
So
of that.
You cannot make this argument that there was material on record
To my
show.
humble understanding, this is a material.
That may be your argument,
Yes,
but
yes.
your contention is that the notification calling for interview and the marks depicted would lead to an irresistible
Conclusion that aptitude test has been held. Now, what is an aptitude test? Is defined. It's not necessarily a chalk and talk method. That I have to be taken to the classroom. I have to demonstrate something in the classroom because
Mr. Mitro has argued.
Yes, because that is
how
not
the education is transmitted through
yes
material.
In my compilation, I have annex some literature. What an aptitude test for a teacher means. Those are there. I have marked those. I am not taking your lordships through that. I have indicated what an aptitude test for a teacher means, and that has, in our case, it has a statutory definition also. Aptitude test is defined under the rules. Rule 2C. When learned judicial officers are appointed, in the subordinate judiciary, my lords take aptitude test. Never my lords take the candidates in a court of law, make him sit in a seat of judge, and takes the aptitude test. It's all in closed door. Now, the Honorable Single Judge was also of the view that this aptitude test, viva voce, in one table, at one go, how could marks be given, by the interview board. Two decisions on this. Just kindly take note of the citations. One is 2015.
You have given here?
Yes, no. 2015, volume 11, Supreme Court cases, page 493. Paragraphs 19 and 20. This judgment relies upon Leela Dhar. My lords are
yes,
aware of these two judgments. Leela Dhar is 1981, volume 4, SCC, page 159, paragraph 8. In both these two cases, there was an allegation that the interviewers, clubbed marks, they did not, allot marks, properly. The Honorable Supreme Court was of the view that cannot be the court's business to look into that, because it is best suited for the employer to decide how they would see whether the candidates fulfill the qualifications or not. It's best suited for an employer to decide the requirements of a candidate, the requirements of a post, so that the candidates attain the threshold of the eligibility. It's not the courts look out to see whether interview and aptitude test could have been taken together, marks could have been given together, whether this could have been clubbed or not. It was like I was trying to find a fault in the process.
In Leeladhar Bicharti
The
paragraph.
Leeladhar paragraph 8.
Para 8.
8 minute. And in Pradeep Kumar Rai is 19 and 20.
Thank you.
Now, these writ petitions, out of which the writ petition out of which this appeal has arisen, was also barred by res judicata because of Honorable Justice Hiranmay Bhattacharya's judgment, because of the judgment.
5 persons are common.
Yes. Yes.
Yes.
And the same allegations were raised, that has been shown to your lordships. And even if the same allegations were not raised, then this would be barred under order to rule 2, which was available, was not argued. So constructive res judicata, if I may say. So it's barred by order to rule 2, by res, by constructive res judicata. Firstly, this was argued. Even if I assume for the sake of argument that this was not argued, that was their choice. Don't all based on a suspicion which is unfounded. I do not call it wild. It's unfounded.
Yes.
Now, coming back to 165, section 165, there is a judgment of Court of Appeal. I am told that has been relied upon by Mr. Mitra.
By Mr. Anindam.
By Mr. Mitra.
Jayanto Mitra.
By Mr. Jayanto. Oh, this is Jones versus National Coal Board. My lords have taken note of that. One more decision of our High Court, that relied on Jones, reported at 2022 SCC Online, Calcutta 3991.
2022.
SCC Online, Calcutta 3991. Milord, on the proposition that Milord, the Honorable Court should not Milord don the role of a prosecutor. Should not leave the mantle of a judge, Milord, come down, Milord, from his seat.
Which was relied upon.
Milord, I am told, Milord, that has been relied upon. Jones, Milord, have been relied upon. May I hand up, Milord, 2 copies? Milord,
Paragraphs.
Milord, last 4 pages.
Jones was relied upon in another matter which was shown.
Milord, kindly then, Milord, take the trouble to have a look at this. Jones versus National Coal Board.
No, that we have that.
Oh.
Jones we have.
And Milord, this Calcutta High Court decision, Milord, division bench decision. Calcutta High Court হচ্ছে West Bengal Board of Primary Education. Milord, I'm told that has been relied upon. Milord, I am not then Milord reading. Now, Milord, so far as para teachers are concerned, Milord, I would be failing in discharging my duties if I do not indicate one order, Milord, passed by Milord's predecessor honorable bench. Milord, that order was passed on 19th of June, Milord, 2023 at page 166 of the compilation. Milord, I have a duty, Milord, to show that.
No, sure. Tell us which paragraph of this 3991.
Oh, achha. Milord, that has been Milord relied upon. My lords have taken notes. So,
No,
Milord,
wait,
let us
wait,
not repeat.
Still give us.
Wait.
3991, which paragraph you are saying?
Milord, kindly turn to paragraph number. Milord, kindly turn to page Milord 47. 47. Milord, the page numbers, my lord, will get Milord at the top on the left hand side.
47. Yes.
Milord, from the very first line, Milord, the discussion starts.
What is the true role of a judge? Where are you reading?
Milord, page 47, Milord, of this
Yes, yes.
bunch. Yes. My lord will kindly take the powers of the court to take evidence under section 165 have been discussed in Ramchandar. Ramchandar in turn, Milord, relied on Jones. And Milord, discussion starts. Then my lords will kindly turn over the page. Kindly take Milord towards the middle of the next page. Jones, Milord, is quoted.
Yes.
Yes. And then Milord, the ultimate conclusion. Page 1. Page number, ultimate conclusion. Page double. But kindly allow me a moment. Stay, Milord, my learned junior will assist me in doing that. Last paragraph.
Yes.
Milord, I just indicate Milord the concluding paragraph. Before I Milord finish, kindly take Milord 166 of the compilation. Milord, this was an order passed, Milord, in these appeals, Milord, on 19 June 2023. Kindly, Milord, turn to the order starts at page 166 of the compilation. Kindly, Milord, turn to page 175, running page 175, internal page 10. Milord, the Honorable Division Bench was of the view that, Milord, these para teachers, Milord, they may, Milord, go back to.
Also stayed by Supreme Court. The second part of the order.
Yes. But Milord, there was an observation.
State cancellation allowed the second part. Supreme Court stayed first, then next the second part was also stayed.
Milord, I'll take your lordship, Milord, to that Milord Supreme Court order.
No,
But yes, that was.
What you want to show?
Yes, Milord, the Honorable Division Bench was of the view that Milord, these para teachers, if they choose, they can go back, Milord, to the learned single judge and Milord ask for a clarification whether Milord, the impugned judgment, Milord, touches upon the para teachers or not. Because Milord, they are lacked clarification. That was the Milord view of the Honorable Division Bench.
Sure.
Page 175.
Yes.
Therefore, again to this mind of this court, although arguable points have been raised, Milord, this was with regard to para teachers. Kindly take it from me. It cannot be presumed that at this operative order, Honorable single bench treated only the aptitude test and not the interview process. The para-teachers claiming to be a part of the interview alone on the basis of the recruitment rules to be videographed, etc. Accordingly, at this stage, until the honorable single bench is given an opportunity to clarify its stand, this bench stands precluded from treating the operative part of the judgment to be of a nature that automatically excludes para-teachers. In the backdrop of the discussion, the appellants are permitted to approach the honorable single bench for appropriate clarification of its judgment. Milord, after that, Milord, an application was filed, Milord, before the honorable single judge, but Milord, in the meantime, Milord, the honorable Supreme Court's Milord judgment order, Milord, came.
Application.
Milord, seeking clarification. The view that Milord, there was something wrong, Milord, in the interview because Milord, someone who did not Milord do well in Madhyamik or higher secondary, Milord did wonderfully well, Milord, in interview or aptitude, in interview or viva voce test. Now, Milord, if the honorable single judge was of the view that Milord, one must Milord procure proportionate marks Milord in the written test and also in the viva voce, then Milord, there is no need Milord to hold viva voce. Because Milord, my performance in the written test will suffice because I'm supposed to get Milord as a thumb rule proportionate marks in interview. Milord, these are all Milord presumption and guesswork.
Yes.
So, Milord, in my most humble submission, Milord, the judgment Milord impugned, Milord lacks Milord logic. Lacks Milord reasoning. Milord, kindly Milord set this judgment Milord aside.
Thank you. Yes.
But these are Milord my most humble submissions. Grateful to you.
Yes, Mr. Where is Mr. Bian? Yes, Mr. Chakraborty.
Conclude, my lord. Your lordship was finding that what is the materials that no aptitude test was held, but some materials were, my lord, used by the petitioners in support of their contention. Aptitude test was not held. My learned senior has argued, but I was not taking any chance. My learned senior has argued that they have used fabricated documents. May I show, my lord, those documents where from it was, my lord, taken that no aptitude test was taken. They have used the documents of 2014 selection test.
Mr. Devarman, you will be having a reply. If anything want to point
On
out-
record, my lord, they have used 2014 selection. Admittedly, at that time, no aptitude test was, my lord, there.
Yes, Mr. Chakraborty, anything? Yes, Mr. Chakraborty. You are also there.
Yes, my item is 92. Item 92, my lord, Dipankar De Mondol. My lord, the appellants are the members of the All Bengal Primary Teachers Association, ABPTA, not ABT, ABPTA, my lord.
No, the association is before us, or the individual.
No, individual. Then members they have I have stated. Yeah.
That is what is the
My
appeal
lord,
number?
I will take only 5 minutes.
What is the appeal number? Tell us.
Appeal number to the appeal number is, my lord, 2188 of 2023. 2188, MAT 2188 of 2023. 2023, my lord.
Yes, Mr. Chakraborty.
My lord, Dr. Devipal used to say one language, my lord, favored child. And I say that, my lord, all those are selected 32,000, all are not favored child.
Some are favored.
I don't know whether any corruption or not. I'm arguing in that, my lord. But all not favored child, not asked for the favor.
How can you segregate them?
Yes, that question will come, my lord, I will reply. My lord, total marks 50, my lord, I've lost knows it, even I am repeating it, my lord. Total marks 50, and for training 15, that is out, 35. My lord, TET 5, education 15, and interview and extracurricular 15. Total 35, my lord. But those who have done well in TET and in academic career, their position in much higher than those are the not good academic career. So, my lord, in interview, only in the hands of the person's interview. In every district, my lord, there are some students, they are academically well. The selection committee bound to select them, because in selection committee, not all are the political persons.
Pardon?
Not all are the political persons, my lord. My lord, Lordship knows earlier days, my lord, in Panchayat, political persons, not our political persons. Only chairman is the political persons there. And others are the brokers. Broker does not compromise with always not compromise with the political persons, because their service, they have to answer before the court. They are very scared about these persons. My lord, interview my lord, in interview, those who are academically high, my lord, and not ask for any favor, from interview result you will get there.
Yes.
In interview result diagram. So, my lord, interview result, you will also see two types of marks given. If you lost 6 is the 8. Somebody has given 5 and above, and somebody has given 5 and less than 5, even 0 there. Even they have to select that person. Even those who got interview 1, they have to select that person, because due to their academic career and their result in TET.
Then what you are arguing then?
And that is my submission, my lord. All are not the favored child, not asked for any favor. This is my submission, my lord. In that circumstances, my lord, those who are academically well, those who got the better marks in written test and aptitude test, my lord, whether they will be punished, saying that you are also favored person, favored child. This is my respectful submission, my lord. Out of 32,000 in every district, losses will find that not all got the support of the interview board, but they have to select. If you go to the interview result, my lord, score sheet, losses will find it. Those who have got below 5, below 4, below 3, even them they have to select. They have to select because their academic career, because their brokers did not compromise with them.
Yes.
Only chairman is the political person, and others are not, my lord. And losses can remember in Panchayat service, my lord, there is a selection of the Panchayat Kurmi, Gram Panchayat secretary. SDO is the chairman, BDO is the convener, and Panchayat Sabhapati, he is political person, he is also member there. So 2, 3, 4 persons are there. If you see that time it is found that the Sabhapati, who is a political person, he is giving 10 and somebody is giving 1. But those are officers, WBCS officers, they have not done it.
Yes.
So in that circumstance, my submission that whether those who are academically well and does not ask for any favor, not have taken any favor, whether they will be punished, my lord. And then I say, my lord, about 5% will be there, 5 to 10% will be there. Those who have not asked for any favor from any person. Anyway, and there the, my lord, I'm saying all not come to as under the because we have not collect the but there are many persons, they are saying that we have not asked for any favor. Whether they're corruption or not corruption, I'm not going there.
All right. Thank you.
So, my lord, this is my submission, my lord. Those who are not academically well, just kindly think for them, my lord. I'm not submitting about Supreme Court judgment. I'm not submitting about the merit of the writ petition, whatever it is. I'm not assessing the judgment of the Honorable Trial Court, my lord, because I'm submitting this because all are not get opportunity to get submit before the trial court. Trial court. That is my submission. So, my lord, losses kindly think. Here, my lord, some appellants, their honors graduate, MA graduate, honors in mathematics, honors in mathematics, MA in Bengali, honors in Bengali. They are also selected. I asked them why you have taken this service. Well, tell me where there is a service. And this post, my lord, nothing but just above the peon. Just above the peon, a primary teacher's post is just above the peon or the group D staff. So for this academic, those academic year, they have selected without any favor. They are not the favored child. This is my respectful submission.
All right.
My lord.
Thank you. Yes. Yes, yes, Mr. Biani, which is your application? You are supporting whom?
No, I'm not. I'm neither supporting anybody nor. I tell you.
Then what exactly you want?
There is an application for addition of party in 92. Amara losses can you say 90 item 92.
Addition of party.
Possible said that in the final judgment. Possible.
What is your application number?
Can 3 there? Can 3 is there?
Can 3. This was filed by whom?
Some party manager. They are also member of the ABPTA.
You are representing them.
No, I'm not. One of them, my is it there? Is appellant.
I believe, my lord, 92 appeal on my learned senior friend, and my lord in 92, my lord, there was a can 3, my lord, filed by the identical
2188. 2188.
Item 92.
Oh, huh.
Identical person of the appellant filed the can application
They are
amongst
selected
32,000.
persons. They are selected.
Amongst 32,000.
So what is it? We have heard you. Can three?
Can they file long before, because this is
No, you have not been your application. Your names have not come in the cause title of the matter.
no, can 3 is there, can
Three may be there, but kindly there are more than 100 applications filed. So only two
when
persons-
the all additional party I had lawsuit will allowed
we have
in the
heard
final.
you, allowing at this stage on a junior applicant. These persons at this stage in the we have heard you, we have gone your government. Yes, Mr. Biani.
My application in short is application CAN 26.
92.
CAN 26 in connection with what?
Connection with MAT number 873. Priyanka.
That is the board's appeal.
Lordship. My case in
You are claiming to be similar to?
I'm not claiming to be similar to anybody. My case is completely different. I have been a victim of circumstances. And I can tell you, Lordship, in just in 2 minutes, I'll show you, Lordship, the documents. But I am a officially declared trained candidate in 2014. But I apply for, given a job in a Hindi medium school as a trained candidate. I am working there, made permanent. Now, this series of these bouts of litigations come in. Pursuant to this honorable court's order, Lordships are aware, everybody had to submit their documents fresh to the Central Bureau of Investigation. I do that. In the meantime, I've written to the board several times that this is my higher qualification DED. Kindly add them in my resume. Now, this court directs that all the documents are to be submitted for fresh appraisal. I have submitted. Now, the list that has come out does not take into consideration my higher qualification.
Which list has come out?
The list pursuant to this honorable court's direction.
On the mornings matter, your lordship.
No, there's a difference. I moved a separate writ application before this honorable court saying that this is the problem. This honorable court, after having considered everything, disposed it off, sending me back to the government. That kindly consider this. The government has passed an order saying, considering all my documents and saying, yes, he is a trained candidate. His trained candidate and this higher qualification should be counted with the date of his joining in the school. Now, bereft of that, the list that has been published has gone down as not getting anything. So therefore, today, when ultimately
that is a cause of action which you will pursue independently. And we today morning we have delivered a judgment saying that because it was submitted on behalf of the board due to pendency of this matter, when the records were called for
Lordship.
of 2016 selection process, all the records may not have been scrutinized properly.
Correct.
That is why there had been entry of names of say teachers,
Lordship.
but they have been marked as para teachers.
over here,
We have said that this is the appointment letter, this is the scale he is getting. Question of taking any contrary stand does not occasion. Even if there is some error, that does not disturb your state.
well, that is my endeavor to point that out that this is the inadvertent error.
We cannot do that in this matter. You can take appropriate steps. You can withdraw your application and take.
Well, if your lordship kindly, when it's at least, my lord, says, falls from your lordship, this is the present position why I am aggrieved. That will help me out in my for the situation.
Aggrieved in the sense.
Aggrieved in the sense that.
Mr. Biani, you consider whether taking away this to take appropriate steps will inure to your benefit, and if you find that it cannot do so, you want an order from us.
Lordship.
Then you please come back and tell us.
Very well.
But we are not on behalf of the applicants and everything. We have concluded the hearing. Next date we will start hearing the writ petition.
Well, before that, next day when his lordship starts, may I take 2 minutes of your lordship time after coming back that this is the position? Because today
after you see the order which we have,
I'll come,
today,
Lordship.
it will be uploaded.
Lordship, I'll come back.
Tomorrow or day after tomorrow, I think if you go through that order and the contention of Mr. Biswas, I don't think there will be a problem.
Well, his contentions are always wrong.
Mr.
details
প্রথমে লিখো মিস্টার অনিন্দ লাহিড়ী, learned advocate appearing for the
heterogeneous group, my lord, para teachers are also there, non-para teachers are also there.
Acha, Majilan, appearing for the appellants in MAT 1368, 1368 of 23
and my lord, MAT 913 of 2023, item number 97. That is, my lord, exclusively for para teachers.
913. Acha. Kim Banerjee and Mr. Chakraborty, advocate appearing for the appellants in MAT 2188 of 2023 have concluded their arguments. Yes, Mr. Kumar, please tell us how many advocates are there for you?
Five or six, madam.
5, 6.
Five. Madam, whatever. I'm just telling you lots
Now,
of
who would be the, Mr. Who would be the lead counsel?
But different issues are there. Factually, from the day one, I was there in the matter. I will argue on the factual aspect. Mr. Mujumdar is also there. Mr. Vikas Bhattacharya is also there. He's appearing for some cans and other aspects. Four, total four.
Seven except can applications are concerned, there might be difference of submission. But so far the issues are concerned, it is the same. So
There will be no repetition.
No repetition. So chance of repetition.
The is going to release the matter.
Open access.
On 21st as fixed at we would request you to make it a bit concise. If so many persons, it becomes very difficult. So far as the app, let us just we are just interacting in respect of we found the orders, Justice Sales order and said in those that one counsel would be hard representing them.
Well, that was
just if you have any objection, you let us know. What we are wanting to do is whatever judgment we deliver, it will be affecting all the participants in the selection process. Now this voluminous brief, now if we send them to the department for incorporation of names of more than 1,000 persons, it will be physically difficult. We can take down your appearance and your, as Mr. Chakraborty said, his junior will be there in the can. He will give his number, name. So at least that can go down in the order that we heard your contents also. To that, if anybody has any objection, we will be disposing of along with the main matter all the connected applications. But it will be really cumbersome if we send them back to the office and directly. So now we are fixing on 21st. We will be taking up hopefully on, if you can manage the dates, we can take it up concurrently and finish it off.
Very well.
There was a direction to produce, my lord, one resolution on the
panel.
last occasion.
Oh, Mr. বিশ্বাস, the 30th November resolution, which Mr. Sen was showing. He said
I've
that
seen your
it is
lordship
on-
last order, but since there was, I will hand over your lordship.
Please, yes, we have directed production of that.
I will hand over.
I don't know whether it will be, please produce.
Well, may I come back on 21st? If
21st,
your
my lord,
lordship
I will.
orders cover me or not, I'll make that submission. On 21st, if your lordship's order in 18 to 20 covers me or not, I'll
How
come back.
can we stop the advocates from coming to us?
Without praying, how can I appear? Lordship.